Already on two occasions I have mentioned.
Yes,
Lordship, there is, I am told the records are not being sent.
records
some-
not be.
Not being sent before Lordship. Records are not being sent.
Well,
Happy. Read.
My lord,
may Lordship kindly leave to mention, my lord. May Lordship kindly leave to mention, my lord.
Yes.
This matter was taken up twice by minor, my lord.
Kishore.
Once on 9th of June.
Yes.
Good morning, bola.
Yes.
The matter was related.
তোমাকে ঢোকালো মনে করো
ঠিক আছে।
এখন গার্ড করেছিল বুঝতে পারছি বলা গে
It's at the motion stage.
My lord, with
May I-
regard to item number 1030 and 1031
No, no. Supplementary thing.
of combined list, my lord. It's a e-rickshaw matter. It was supposed to appear on 2nd of August, my lord.
Yes.
And similar orders were
Taken up. How many matters?
my lord, may I be permitted to mention this matter for upgradation, my lord? This is item number 41 of the monthly list. My lord, the urgency is the respondent number 4 is trying to transfer the excess vacant land to a third party for the development of a
the monthly list.
monthly list. For the development of a go down, which is not permissible because the exemption order says that part of the land shall only be used for business purposes, my lord.
May Lordship
My
kindly
lord, may I
mention,
be permitted to mention, my lord, on urgent matter, my lord. My lord, tomorrow is the date for, my lord, demolition of the building, my lord. My lord, and my lord, another matter, my lord, item number 121. My lord, similar, my lord, demolition will be held, my lord, tomorrow. Your lordship take this matter anytime today, my lord.
121 of the supplementary list.
Yes, my lord.
Let me see.
but
My lord,
May Lordship
anytime, my
kindly-
lord. Otherwise, my lord, it was, my lord, difficulty, my lord. Matter will be infectious. If your lordship so desires that demolition of the building is not a urgent matter, then, my lord, I have no case.
Let us
My
see.
lord, let them, my lord, any time, my lord, at the time of rising, so I will bring the other side, my lord. My lord, kindly, my lord, fix, my lord, any time. My lord, I requesting your lordship. My lord, I am requesting your lordship, my lord, any time, my lord, let the matter be. My lord, last Friday, my lord, I have mentioned. Yesterday also mentioned. Today is.
I have heard you, sir. Yes.
Huh? Other side? Yes. Yes.
Oh, give the number, please come back at 1 o'clock.
My lord, item number 121. And other matter, my lord, I have supplied the.
120 একটা সময় রাখবো।
Yes.
May Lordship
Grateful.
May Lordship kindly leave to
Mention one matter, my lord.
May Lordship kindly to mention, my lord, the combined list, my lord, item number 350 matter relates to, my lord, unauthorized construction is going on, my lord.
It's
On
in
the PWD land.
monthly list.
Monthly list 355.
May I
I am praying for updatation, my lord, for e-rickshaw registration matters, my lord, covered by the lordship's judgment, my
How
lord.
many matters?
My lord, 3 matters, my lord. For similar order will pass.
May I be permitted to? দিদি ই-রিকশা গুলো একসাথে রাখবেন। এর আগে দুটো ই-রিকশা ম্যাটার মুভ হয়েছে। Please mention as e-rickshaw matters.
Yes.
Because it will be difficult to identify
My
otherwise.
lord, identical matter, my lord,
Please mention them as
Mention.
e-rickshaw matters.
similar matter.
Please mention as e-rickshaw matters.
Egress and ingress, similar matter.
May I be, yes?
Egress or ingress, my lord.
How many matters are you giving?
Egress, my 3 matters.
Yes?
3 matters. E-rickshaw? No.
I'm
My
talking
lord,
about
may I
e-rickshaw
permit-
matters.
Oh.
My lord, may I permit to mention one updation of motion, my lord, from monthly list to supplementary list. My vehicle is keeping idle. My lord.
Yes?
My vehicle is keeping idle.
May I be permitted to mention one matter, my lord? Urgency in the matter involved, my lord. The petitioner herein, after getting the permission from the Gram Panchayat, has opened a small poultry farm, but the DM concerned revoked such permission without considering the government relevant notification. The challenging the said decision, the petitioner herein has filed the writ petition, and now the business of the writ petitioner has totally.
Contract matter.
Yes, my lord.
This court doesn't have determination.
No, challenging the order of DM, my lord.
Give the number, let's.
Lordship, may I permit to mention item number 750 of the monthly list, Lordship. Unauthorized construction is going on, Lordship.
My lord, I am mentioning
application,
Great.
My item.
What is the matter? The number.
May I mention one matter, my lord?
Please.
Item number 1027 of pilots combined monthly list. Milord, the urgency lies milord in the fact that milord, the DM has issued an order milord for immediate dismantling of my mobile phone towers despite milord I have paid the interface. Milord, usually what used to happen milord, the municipalities used to collect monies milord for installation of towers. Now milord, in 2020 a single window system milord, the state authorities milord have milord introduced. Milord, under that single window system, milord, you have to put in money once, milord, at a time. Milord, I have put in that money. Milord, there are orders, milord, passed by the milord, honorable coordinate benches to that effect. Despite milord that fact, milord, the DM has
Keep that up.
issued an order.
Milord, may I be
Milord,
Milord, may I say one matter?
My lord, 749 of the combined list, my lord. My lord, the matter was
এটা একটু উপরের দিকে রাখো, dismantling এর ইয়ে আছে। Yes,
My lord, unauthorized construction,
749 of the combined list.
unauthorized construction, lord, so is going on.
My lord,
Payment.
my lord, the matter was appearing in the supplementary list.
Registration of the lease deed.
The matter was appearing in the
petitioner
supplementary.
And the government has given the report in the form of affidavit, my lord, it was fixed on 1st of August in the monthly list. But since the matter did not take
not
place,
appearing.
Milord, may-
My lord, my lord, your lordship called for report and the matter was appearing in the supplementary list. Thereafter, my lord, in the monthly list, it is appearing in 749. All on a sudden. In the supplementary list, what is appearing? Kindly see, my lord.
A long supplementary list. I don't know how it will help.
Milord,
This was appearing in swap.
Please wait, sir. Your seniors are waiting. Please have
But
some
this is
patience.
urgent matter, my lord, regarding the stand query, my lord, it has been stopped. And my lord, your lordship
I said
directed,
give the number.
yes, my lord.
Milord, may I mention?
Item number 138, my lord.
Please.
138.
This matter I mentioned on 25th July, my lord, not allowed my mentioning matter, the petitioner senior citizen matter. My lord, matter, this petition came as my lord, 2018 matter came as 1 Now, my lord, direction was given in the year 2018 for extending affidavit, no affidavit filed. Now, my lord, when the matter came in the 1 my lord, my lord, notified, my lord, the learned advocate was appearing, he did not come, twice notified. Thereafter, lordship directed my lord to serve all the respondents with the petition. I again served. Nobody appeared. Lordship directed to serve my lord to the government bidder. I served on Mr. Bondopadhyay, Subito Bandyopadhyay appeared. Lordship extended the time on 31st March for filing affidavit, no filing affidavit as well. The issue involved, my lord, is covered by your lordship judgment, my lord. I have with me, my lord, in other matters, my lord, only to my lord, direction be given, my lord, to the concerned block land and officer, my lord, to quantify on inquiry to quantify the quantum of the sand and to my lord take royalty at the rate of ₹15. That is also an interim order passed by the honorable coordinate bench. Only that issue also directed my lord to appear this matter, my lord, hearing at the top. But unfortunately, my lord, the requisition has been said in some 2018, my lord, it sent my lord 2022. My lord, again, my lord, requisition has to be sent. 25th July, my lord, it was mentioned.
Please give the correct number and
Milord, may I mention one matter, Milord? May I mention one?
give the name.
Milord, may I mention one matter that I have been mentioning for the last 1 week? This matter regarding demolition my shop room. The DM's order of the shop rooms by the side of the PW. Now I have filed this application in the month of June. 2 months I've been mentioning, last week also I mentioned that they have recently sent a notice to me that we will demolish the same on today at 12.
It's at section 10 proceeding.
Yes, my lord.
Have you put the other side on notice?
Yes.
Who is appearing for the?
But Mr. Dey was appearing all along. Mr. Chandicharan Dey, all along.
Dekhi notice to dekhi.
Can you see it? I mentioned it tomorrow, yesterday also, my lord, last week also. I have received this notice on 14th August. I mentioned it 16th. My lord said on Monday you come. Yesterday I mentioned. Kindly pass status quo. I've been there for the last 50 years, not in a what, suddenly.
But you're encroaching for the last 50 years.
No,
sir.
no. I am not encroaching. I have been encroacher by acquisition. I was there in my paternal land.
Yes, so it's better that you leave the land and you vacate the land.
Yes.
Who is appearing? Please come at Barat Shomar Rakuntu.
My lord, I'm
My lord,
mentioning
may I be-
At 12 o'clock, I'll just get the record.
Yes.
Huh?
Only
দেখুন কোথায় আছে জিজ্ঞেস করুন
My lord, I'm mentioning
ফাইল কোথায় আছে
item 138.
file এখানে
of the combined
947.
list,
947 item. Yes, 947.
My lord, exception.
So 7.
Upgrade it, only this pair, my lord.
Give the number.
My lord,
What is your urgency?
Hello?
And the land has been acquired by the land has been but no compensation.
Give the numbers.
Lord, may be allowed to mention a matter for demolition will take place tomorrow. By urgency is that the respondent without giving any notice had inspected the plot area and not giving any notice, any instruction to the private petitioner. My urgency is that they will demolish the only shop room of the petitioner.
You have received a notice of demolition?
No, I have not. This is the police has instructed, they will demolish the notice upon instruction of the DM.
Show me the notice. of
I have
the
instruction. I have served upon the private
Lordship may
respondent.
be
They
permitted.
have served.
Demolition?
I have not received the demolition order.
Then how do you know that will be demolition?
Police has instruction that they will demolish the order.
Give the number.
My lord,
Lordship may be permitted to mention.
my lord.
One upgradation matter for running in the monthly list 346. The urgency is that the Vastu land has been wrongly recorded as Pupul land, and the petitioner's father is in the owner of the property and he is about to die. So it may be rectified.
Wrong recording, this court will not have jurisdiction at all, sir. Madam, it's under the specified act.
My lord, Lordship, there is involvement of the wrong recording, not only the misappropriation of the property also.
You just now submitted wrong recording. So please find out and come back.
My lord, may I be permitted?
Not jurisdiction.
There is misappropriation of the representation also. We have sent the
Misappropriation of?
representation.
What does that mean?
That has been corrected firstly, that has been received. And after that, that has been scratched out.
It relates to land. It relates to the Land Reforms Act.
This
Land Reforms Act. Give it a to be mentioned. Release korte hobe.
My lord, may
May I be.
kindly mentioned.
This is from the jurisdictional point, madam. Let me inform you earlier. If
My lord,
this
may I
is
be-
from the jurisdictional issue, please come prepared.
my lord, may I be permitted to mention one matter, my lord?
Several mentionings taken already. I think until tomorrow.
My lord, one mentioning, my lord.
My lord, for inclusion.
My lord, for inclusion, my lord.
My lord.
Is happy?
My lord, the
My lord,
interim
may I
order-
continue for inclusion, lordship.
Yes.
My lord, the interim order of these writ petitions is expiring on 31st of August.
So come back to 31st of August, not today.
My lord, may I be permitted to mention one matter, my lord?
Yes. Can you come back tomorrow? I have taken sufficient mentionings. This will really not help you, madam, if I take up the entire monthly list into the supplementary list.
My lord,
And I will not upgrade supplementary list matters. I've made it very clear. However urgent the matters are. Not possible then like
I
this.
understand, Malad, in my case, Malad, may I just make one
Yes,
small
what is it?
submission? I know it's very, Malad, I shouldn't be making such submission. Malad. My client is 90 years old. Malad. Her plot was mutated. Malad, no reason order given. It came back to your lordship, Malad. 4 times the other side took time. After pleadings,
The
Malad.
hearing matter.
The hearing matter, Malad.
Evidence are complete.
Everything complete 1-2-1-1, Malad. But the point is, Malad, she's 90 years old. But I cannot, Malad.
It a hearing রেখে দিন তো উপরের দিকে।
My lord, hearing matter, my lord.
my lord.
Tomorrow. Remaining mentionings tomorrow. Yes, you are waiting from yesterday. Yes.
My lord.
Substitution. Give
My
them.
lord,
My lord, hearing matter, my lord.
My lord, may I?
Hearing matter.
Yes.
Hear anyone.
My lord, kindly. My lord.
98 years, my lord. He has a he's suffering with various alignment. My lord, petition is a phenome python.
Yes, I understand he's suffering. Let him suffer for another day. Please come back tomorrow.
My lord, kindly.
Yes, call the case list, please.
Restoration, my lord.
Case list tomorrow. All urgent matters tomorrow.
527th, my lord.
You still have some time, sir. Today is 22nd. So you still have some time. Come back tomorrow.
My lord, may I permit to mention for restoration?
I don't know, 75.
Please come back tomorrow, sir. I'm repeating. Please come back tomorrow.
That is why, my lord, I came from RI.
Yes.
Only for inclusion of it.
What is your urgency, sir?
Urgency is the non-considered deficit of nothing more.
Deficit of court fees. What is that ground? I do not understand.
Yes, my lord. In the year of 2019,
Yes.
my lord, kindly
What is the
consider my
issue? What is the issue? Why have you filed the writ petition?
Non-consideration, the payment of deficit quota. Nothing more.
I do not understand.
Land matter. In connection with the land, I purchased the land.
Yes.
Deficit, there was a deficit of 4 fees. Thereafter, I pay for
Deposit of court fees or registration fee? What is the difference? Stamp duty? Yes.
Difficulty is that whenever I want to pay the deficit court fees, stamp duty, they rejection my prayer. That is my
Give the number, let me see.
My lord, hearing matter, my lord, 3 analogous matters, my
You
lord.
have said what I've just, you've heard what I've just said.
Yes, but your lordship told me.
Include
to mention it better today.
রাখুন দেখছি তো land matter বলছেন দেখি Yes, item number 1. Who is
Sir, I am for the petition number 2.
For
the
I'm for the respondent matter.
the petition is asking for a release of
This
this.
matter, Lordship had heard it on few occasions, my lord.
Yes.
I know Lordship is overly burdened with the jurisdiction, my lord, but we would always pray and would be happy to make
The
argument before your
petitioner wants,
Lordship.
the petitioner wants a release. So let
But this was assigned before your Lordship. Lordship has been pleased to hear it on several occasions also. We would not
has it been
be
marked as
praying that
part?
Yes, it has been marked as part of.
Marked as part? Your petitioner number
Petition number 2.
the second petitioner seeks release of the matter. Paragraph. In view of the same, comma, the matter be released from the heading part 30 inverted comma মধ্যে দিন and also released from the list.
Grateful.
obliged on that.
I'm good to go.
Item 2.
My lord, I am appearing for the state, my lord. My junior already submitted the report, my lord.
How are you now?
At present, my lord, okay,
Your leg
1
is
week,
better?
2 weeks, to time. Lord,
I will led by Mr. Ansar.
Yes.
But no, with in view of
Why
the
did you mention?
Blood, because blood, there's nothing blood remaining in this matter because blood, the relief that I have sought, blood, that is almost met because the state says that this property, blood, they are not in possession and therefore, blood, there was no wasting. Now, blood, kindly come to my prayers, blood, in view of the affidavit that the state has made as of now.
The state has come up with an affidavit.
Yes, blood.
Persons of- yeah.
But if your lordship kindly sees their letter at page 4 of the supplementary affidavit, the instructions, blood, as it stands at page 5, but the second paragraph, it appears that the said land along with structure on it was kept beyond the subsequent proceeding of acquisition on the request of the owner. The property thus may be treated as released from acquisition.
Today's supplementary.
Didi, apni handover করেছেন? Supplementary টা?
Yes, ma'am, just now I have. This today's, yes. Paragraph.
But kindly come to page 5. This is not the state's letter of the joint secretary.
Yes.
It says that the second paragraph, it appears from the said land along with the structure on it was kept beyond the subsequent proceeding of acquisition on the request of the owner. This property thus may be treated as released from acquisition. Therefore, my lord, my prayer was that they should not release the property, and this is not that what they say. If the possession is still with the petitioner and their family resides on the plot, which is a building one.
It's a fact.
This is a fact. If the
Lord,
fact is treated as released, the petitioner is not eligible for any compensation.
Absolutely.
Let the matter be placed before the honorable court for approval and kind order as it is sub judice. Lord, in view of this,
Nothing further remains.
only one thing, Lord, they have already, Lord, changed, Lord, the LR record of rights. Lord, in terms of my prayer, Lord, at page
That cannot be done by this court.
But I understand, Lord, if your lordship kindly makes an observation to that effect, I'll go before Lord the appropriate
That
authority.
cannot be done. You're aware that cannot be done.
As your
It's a
lordship.
specified act, you have to apply before.
I bow down to your lordship, Lord.
So let this be disposed of in
My
terms of.
In terms of the
in terms of
affidavit,
the-
yes.
Absolutely. Supplementary affidavit submitted on behalf of the state respondents is taken on record. Paragraph. Heard learned counsels for the parties.
Sorry.
Paragraph. The petitioner has paid for a direction upon the respondent authorities to pay compensation in respect of requisition and acquisition of the land of the petitioner in terms of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013. Stop.
Lord, that's 13 decimal will be Lord stand released, and in respect of Lord that is acquired, Lord, they are to pay Lord the compensation. Lord, kindly see prayer A. This is Lord in respect of
Land already released, my lord. So there is no question for compensation.
but kindly come to my prayers, Lord.
Yes, you've not mentioned the quantum of land in your prayer.
কোথায় quantumটা বলা আছে? Yes, Lord, prayer B. Prayer B.
Yes, 6 acres.
And this is not in respect of 13 decimal. I'm not joining any issue over 13 decimal. Very well. Mr. Mondal has said that it has been released, it is released. But in respect of 0.6 decimal, Lord, I'm entitled to compensation.
The affidavit is only in respect of 13
For 13
decimals.
is the first paragraph. First paragraph of the affidavit.
also
That
says
letter,
13
page 5.
decimals.
Yes.
No whisper regarding the remaining
No.
part.
No.
But your writ petition involves the entire is
13
isn't
plus
it?
6.
So what about the remaining
The-
6, Mr. Mondal?
Lordship, on the basis of the prayer of the petitioner, my lord, the concerned land already released, my lord, in favor of the petitioner. So
That is
remaining the two,
That's 13 decimals.
lordship,
What about the remaining 6 decimals?
the already concerned the area of the 13 decimal, my lord. The acquisition department not related with the remaining 6 decimal. Only prayer, lordship, my lord. There is no any indicate the writ petition, my lord. So at this stage, the concern the 13 decimal, my lord.
Lord,
Prayer B says-
on instruction, I say, Lord, we will reserve that right, Lord, for a later proceeding.
That's what I feel. If the writ petition is disposed of, that will
Lordship.
not serve your purpose.
Lord, so far as Lord,
This is only a part of your prayer.
that is Lord, and so far of other remaining portion is concerned, Lord, there has been a road, Lord, constructed on that Lord property.
You've not received compensation.
No,
for the
Lord.
same. So you're seeking compensation for that.
Yes,
In the present writ petition.
yes.
So if this is disposed of, you have
Lordship,
further,
but-
cause of action.
That is Lord, what I am praying before your Lordship, Lord.
It can be done this way. Do you have a representation pending for payment of compensation?
Yes, Lord. Kindly, Lord, have a look
That
at
means I can direct the authority to pay compensation to dispose of your representation.
কথাটা বলতো। তো এটা তো RTI. That's all. But kindly dispose of in terms of Lord the affidavit.
In terms of?
In their this It's very bad.
Because the documents annexed to the writ petition says it's only 13 decibels.
Look, I understand. There's some confusion on instruction. That's the reason I say. Kindly dispose in terms of blood.
Very well. কি বললেন?
This is not a conference time.
Paragraph, it appears from the supplementary affidavit submitted on behalf of the state respondents that the land in question, along
Why
with
do you
the
keep all these
structure on
nonsense
it,
submissions? I fail to understand.
comprising 13 decimals in plot number 865, was not included in the acquisition proceeding and therefore may be treated as released from acquisition. Stop. It is not in dispute that the said land is in possession of the petitioner who resides therein with his family. Paragraph, in view of the above, comma, this court is inclined to hold that nothing further remains to be adjudicated in the present writ petition and the same is accordingly disposed of.
I'm great. Lord, I'm great.
Urgent certified website.
Lord, I highly oblige you.
But I'm
Yes, please.
sorry to give your lordship the trouble. But, there was some
Prayers also say so.
prayers 7 plus 5, my lord. I was not misled. 7 and 5 makes 13.
13, yes, yes.
But
So it's
that-
the
that-
entire.
that is the
quantum,
entire,
yes.
And that they say entire, my lord, the 30. I apologize.
उनको तो क्या है क्या से क्या है?
You mentioned এটার জন্যই নাকি? ওই তো আছে। Yes.
My lord,
Respondents?
I am for the petitioner, my lord.
Item 3.
This matter had lastly appeared before your lordship of 19th of June, when lordship had been pleased to extend the interim order till 31st of August, my lord, and directed the state to file their affidavits, my lord, peremptorily.
It is not, it is, you have prepared and it is sent to the department, but it is, they have challenged the virus, my lord. It is, as per my instruction, it is before the learned EG, my lord.
But I can understand.
Praying, extension of time, my lord, and, kindly extend the interim order for a limited period, probably we shall file that.
My lord. And
Your
post
response
vacation.
For the state respondents seeks extension of time to submit the affidavit in opposition as prayed for, as called for. Paragraph, since the interim order granted earlier expires on 31st August 2023, comma, the said order be extended till 30th September 2023 or until further orders, comma, whichever is earlier.
Grateful, lordship.
Lordship, kindly extend the period of affidavit.
No, I have a still.
Item 4.
September.
Item 4, lordship, Mr. Pan is appearing
Item number 4, I appear you.
on behalf of Mr. Pan, lordship, I pray only not today, lordship. I'll give you a date. Yes, yes. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 1st September. 1st September, lordship.
Item 5.
But I'm for the petitioner.
You are the petitioner?
My lord, on the 12th August 2021,
Mr. Shadhu.
My name is recorded, my lord. Your lordship, kindly appointment should be regularized. Otherwise, I
You appeared for the state?
No, my lord, in this matter, I am not appearing, but name is recorded, my lord. Your lord,
Yes.
kindly regularize my name, my lord. Then my lord will appear, my lord, with Mr. Learned Senior, my lord.
My lord, on 12th August 2021, this honorable court directed the state to take instructions.
Yes.
And my lord, this is August 2023.
So who is appearing for the state?
Yamin Ali, my lord, most probably, Yamin Ali.
Mohammed Yamin Ali and Sahidul Islam.
Yes, my lord.
Later, my lord, Mr. Amrital Chatterjee was there, and sometimes Mr. Sadhu's name is in the record.
My lord, your lord.
Yes, you're appearing.
Lord, if your lordship so desire, I can appear, my lord, in this matter, my lord.
No, but someone was appearing in this matter.
Yamin Ali, mara gache.
Mr. Ali was there. I am told Mr. Ali was there. He is
Mr.
no
Ali
more in the
and
world.
Sahidul Islam.
No, nobody is there.
They are not in the panel.
No.
So a fresh notice has to be served.
Mr.
My lord, already served, 2 times served to Mr. Amrital Chatterjee. Mr. Amrital Chatterjee, who appeared before.
No, I do not find his name at all.
Huh?
You have to serve the GP's office because the panel has changed. And these advocates, they are no longer in the panel.
Last day, my clerk went to the GP's office,
Yes.
and that he was told that Mr. Amrital Chatterjee is in this matter. And last day, Amrital Chatterjee received the letter also. My lord.
Oh, how panel?
And before that, before on 22nd March, Mr. Chatterjee also received our notice. My lord, kindly see. 2 times we served notice upon the state.
I do not understand why you're serving on the learned council. You have to serve the GP's office. Let the government leader direct some.
Oh, my lord, I will serve. I will serve. Well, as they told that.
You cannot directly serve. You have to serve because there's been a change in the panel.
My lord.
So you have to serve the GP's office.
My lord.
Let the GP entrust someone.
I shall.
Because direct appointments cannot be done.
Yes, my
lord. I shall, my
If no one appears despite service, then I can request.
Lord.
someone. Not before that.
My lord, kindly fixed after 1 week, my lord.
None appears for the state respondents. Since there has been a change of learned counsels in the state panel, the petitioner is directed to serve notice upon the office of the learned government leader and file affidavit of service on the adjourned date. Yes.
My lord.
Paragraph, let the matter appear under the same heading on 4th September.
My lord. All right, my lord.
Item 6.
I am for the municipal response. I will be
Kindly come to prayer of my petition. Page 42.
Yes.
There is a bus terminus has been settled there. This is our grievance. Municipality filed an affidavit saying that there is a bus terminus they have not permitted. State government also is party here, my lord. They have not filed anything. They have only said that the allegation is not against us. So they are, but fact remains, bus terminus is in my property.
And no one takes responsibility.
No one takes responsibility. And it is not the individual. Bus terminus had One bus has been parked, I could understand, private dispute. If terminus is there, municipality is saying they have not allowed anybody.
No, my first submission is that regarding, sorry. Yeah, sorry.
Yes.
Regarding, my lord, bus stand, you also can see our report, see at page 160 of the report.
You say this is not done by you.
The
No.
report says that not to waste your lordship's time. They have said that they have not.
You have said, no, but I have other points. Because can you see that our resolution is taken by the municipality that this bus stand has not been established by the municipality. It is because of some other purposes. Because the municipality has not established any bus stand at the place claimed by my land.
Page 8, paragraph 6, they have said.
Yes.
The Dum municipality has not undertaken any project to construct bus
Yes,
stand.
yes. I am admitting this.
Yes.
But next, my lord, I raise the question of locus standi of the writ petitioners on the ground that these plots of land have already been mutated by the municipality in the name of several companies, but not in the name of the GTR, on the basis of the documents. So my first preliminary objection is that GTR does not have the locus standi to move this petition in respect of these plots of land, because our duty is to answer before lordship. These plots of land have already mutated in the name of the other companies. Why you have mutated this, my lord? The documents I have annexed here. Why have mutated this document? If you lordship kindly see page 5261, it is very clear of my report or evidence. It starts from 52. It's an order of the land tribunal, my lord. If I place it, then entire thing is very open.
Page 52.
Yes, of my report.
Yes.
But this is a case between CC Uma Sundari Kali deity, state of West Bengal, and GTR is also there. I just read it, my entire facts is very clear from you. The proceedings under section 44(2)(a) Ready section 6(5) of the Estate Acquisition Act are made sumoto by the subdivisional officer under 44(2)(a) of is under challenge in instant petition. It is record of rights revised under the West Bengal Estate Acquisition Act. The subject lands are recorded with the applicant deities as the owners as on the date of vesting order under the Act. Lands are opted to be retained by submitting return in Form B by the shareholders of the applicant deities. Accordingly, the applicants are allowed to retain the lands as desired under Rule 4 of the West Bengal Estate Act rules, and condominiums are made with the subject written lands of the applicant that is represented by the shareholders. Thus, the provision of the Estate Acquisition Act was duly applied subject land, and action for revision of the record of rights was completed in all respects. But after about 40 years, the subdivision officer, Officer Barakpur, has questioned such recording in the import proceeding and held that the lands are actually owned by the shareholders and not by the deities, and should vest in the state as their surplus land. He passed order of vesting in respect of the subject land, also for taking over possession of the same. The case, however, is not as simple as it appears from the facts above. There is a side story which has made the case a little complicated. The shareholders leased out the subject land in 1930 for 10 years. The lessee was declared insolvent in 31. One court's order of leasehold interest of the lessee was sold. One GTR, my land client, has purchased the leasehold interest. After expiring the period of lease, the lessor shall institute a suit for eviction of the said company and obtain a decree. The appeal prepared by the company was dismissed, and decree for eviction was affirmed by the order dated 25 July 1942. The company thus lost the case as a lessee. Meanwhile, the state government, by an order dated 1940, requisitioned a little over 4 acres out of subject 10 acres of land under Defense of India rules, and handed over possession of the requisitioned land to said company which was supplying defense materials to the Government of India. The extent of land which was requisitioned under the before India rules is precisely land on the said company had its factory, sheds, and office. The company vacated the remaining portion of the subject lands. There was therefore the position is on the date of vesting of the subject lands, which was rightly recorded in the RS record rights was applicants owners,
As seen earlier, the lands are retained under Section 6 of the Establishment Act. Accordingly, prepared recording lands as retained land of the Daitotv থেকে নেব। In 1975, the said company applied.
Contact you. But these are all irrelevant.
Why?
I am not asking my title here. I am saying I am in possession.
You are not in. Kindly.
You are not in position prima facie.
Yes,
I am in position and send somebody.
I just place it, man. I just
There
place
is
it.
document of possession.
yes, yes.
The
Document of
record of
possession.
rights are not in your name.
I just place it. Then, my lord, your lordship.
Electricity bill,
My lord-
municipality bill, trade license,
My-
factory
Everything,
license,
electricity bill,
sketch map.
trade license, everything is there.
My lord, can you see this
I
order?
am not asking for deciding my title here.
No, the operating, this, what happened? This is what you also, this debtors property. There is a 4 acres of lease out to them. It's evicted. The state government made the requisition. They were, you also kindly come to the operating part of that paragraph 12.
752.
For all these reasons, we hold that the subdivision land and land officer at page 60 has done is arbitrarily and patently illegal. The proceedings number 1 is questioned, all the orders passed, they are in set aside. No land recording in favor of the debtors can vest in the state. The subdivision land and land officer and the block land officer backward and directed to restore the khatiyas in favor of the debtors within 15 days from the date of communication of this order, waiting for approval from any authority. So, my lord, debtors is the owner of the land, and this person. It was challenged by the state government in the writ petition. That was also dismissed, my lord. That was also dismissed.
In a suit with the municipality, we have filed an application for local inspection. Is the report
So,
of the local inspection.
my lord,
So
as
who are
50
these companies in whose name the mutation has been done?
oh, is my lord?
Who are these companies?
I'm saying, there's companies are there. I'm saying, but what happened is this order was there. Now it was challenged by the state government before this high court. Can you come to page at 51? That was also dismissed.
51.
Yes. This order was challenged. So that is portion restored. Page 51. Now the debt is sold those lands. That is sold those lands to the private company. These are companies. On the basis of the deed, we have muted the names of this company. It starts from page 62, my lord.
Yes.
So they are, this is 62, but this is my petty cabinet is my lord, on the basis of the document of the tribunal's order and the high court's order, as well as the sale deed, so executed by the debtors in favor of these companies. We have mutated this plots of land in the name of these companies. It starts from page 62. It's my lord, various companies
Yes.
at page up to page my lord, 142. The land also 42. Then it was recorded in the name of the companies in the land records also at page 143 onwards. So my submission that primarily that Mr. Bosch's client having no locus standi to raise this question in respect of plots of land. This is our mutation, the land mutation, both are in the name of these companies.
আরেকটা পয়েন্ট কোম্পানিকে পার্টি করে নিত
And it is in the knowledge of the Mr. Bosch's client, they should make these companies a party, whether they have the company is in a position or not.
So mutation is a title.
No, I'm not saying the title. I said this is but these are all mutation. I'm not saying that was the title. Mr. Bosa, I say that why Municipal has recorded the names of these companies? Because of these documents. So order of the tribunal, order of the High Court, and the sale deeds. That is so. And their names have also been recorded in the, my lord, record of rights of the land and land department. My lord, land is here. So my lord, if Mr. Bosa says they are, I'm in a position, I'm in injunction, then they have to make a party, these companies. So my humble submission that Mr. Bosch's client has no locus standi to raise this question that for the first time we are not establishing the bus stand, that there's a bus stand in their own land. The order of the tribunal is very clear, my lord. What is the local standing of Mr. Basu's client?
Yes or?
Yes. No, my lord, I thought Mr. Basu would again stand up and say that these documents are not covered by affidavit, so.
Instruction.
So this message GTR was inducted by the state of West Bengal in that property only. When the state of West Bengal, when initially they got the lease and subsequently that particular trust filed a suit for eviction. And Malad, this 10.6995 acres was thereafter out of that 10.6995, state tried to requisition that land for the purpose of their settlement. And Malad, thereafter, Malad, we tried to do 44 2A proceedings to correct the record of rights, to change the RSROR. Malad, that even Malad, we were unsuccessful, that was challenged. And subsequently that was quashed. Now, Malad, this deed was executed in respect of 4 acres of land. Even that was also quashed. So initially 44 2A proceedings was quashed. Thereafter, we tried to give them a lease, long-term lease. Even that was also quashed.
And the appeal was dismissed.
Yes. Then they have challenged the tribunal's order. That WPLRT, Malad, I believe.
That's page 51.
Yes or no one?
Page
That's
51
of my report. This one of my.
The plots are classified as.
So that has been challenged.
During RS operation. I don't know what is the, because in the present condition, I believe means all those deeds which have been annexed by Mr. Rai, Malad, those are not showing this. এটা নেবো দাদা এখানে কি ডিটের মধ্যে পুকুর নেই তো
That is our own case.
ওটা আপনাদের মামলা
This is not a concern.
হ্যাঁ সেটা নিয়ে
করেছেন যে পুকুর বোঝানো হয়েছে
বলে শেষ করো বলি
না না স্যার এক সেকেন্ড স্যার ডিড গুলো একটু দিলে
ডিড গুলো লাগাইনি
ও
তুই এখন পড়ে
well those deeds are not before my lord. Perhaps in the deed there is no existence of pukur or tank.
This is not the issue here.
Another matter is there
For that issue, my lord, they have filed another writ petition that is pending.
The documents say that the pukur is privacy filled up.
Yes.
Then may I clarify? Had it been taken the point first, I could have clarified first.
Dana, sir, sorry.
Ball.
This particular subject land has been subsequently dealt with by the deity in favor of these 4 or companies. Well, they should be a necessary party in these proceedings, and for that issue only, this writ petition should go.
হয়ে গেছে তো?
হুম।
Go হয়ে গেছে?
Yes.
We are the lessee from the original owner.
Tenants.
We are tenant or lessee on the original owner. Thereafter, state government initiated proceeding for vesting cost. After the passing of the vesting order, state government wrote to us that you return the land to the DT. That has been challenged before Lordship's court and is pending. Right?
And there is an order of stay. Yes, yes.
Oh, there is an order of stay. That order is not with me. Had it been a case that
Subsequent case,
taken
subsequent
this,
case. এটার
I
পরে
could have-
হয়েছে। এই কেসে
then
পরে হয়েছে।
another suit has been filed. Whatever for maintainable of this petition, I have only to satisfy that I am in possession. Mutation does not create title. Now, so far as the possession is concerned, kindly come to page 52 of your lordship, please.
The record of rights show possession, is it?
Then come to page 52
Of the writ.
petition. Is the electricity bill?
Page 48. Municipality bill.
This is not a shoot.
Page 48 is my lord,
Municipality
in
bill.
the municipality document.
GTR company.
GTR company has my lord kindly got it. Page 48.
Page 57 হচ্ছে trade license.
48. It might not be satisfied.
Yes, 48.
48, can you see? This is the house down the municipality. This is from GTR company private limited, my client. Then kindly turn over.
Page 57.
Kindly, no, এটা দেখা। Kindly come to 52.
52.
Electricity bill. You lordship go on seeing that, then
Page
minus
57.
57.
Municipality bill.
Trade license department issued a trade license in favor of the GTR and company, 57.
Then again 58.
58. Go on, 59.
There
These
is
are all
60, 61 factory license. 60, 61 is factory license.
Trade license is not issued upon verification of title or
I am
possession.
not I am not on title.
Possession.
Possession, electricity bill is there.
So factory license.
Then
factory license.
factory license page 60.
Valid
And
up
another
to-
document is showing to us immediately.
Now valid up to কবে দেখুন?
When
31,
kindly come to page 60. Factory license cannot be on the year. Page 60. Valid up to 31 December 2023.
Issuance.
Now, my lord, another document I want to show to your lordship, which is, I don't have any extra copy. It was, all on a sudden, this point has been taken. There is a suit filed by my client against South Down the municipality. Order 39 Rule 7 application has been filed for inspection. And this is the inspection report. After this, my lord, they will say that I have nobody. But I have only one copy, I cannot share with my landed friend.
The companies also appear to be somebody actually. That's the difficulty.
My lord?
The companies in favor of whom the DTs have transferred, they also appear to be somebody in the property. Because their names are also recorded.
Only mutation has been made, that is all clear title.
Right.
Title.
And what is my prayer? My prayer is that in the property, there is a bus stand, remove it, that's all.
Who are you to say?
Here I am, can you see the report of the London Special Officer or the Commissioner? চুপ দিচ্ছি।
একটা supplementary করবি, তাই তো?
একটা কপি আছে। হঠাৎ করে বললে রমি হবে।
কোন সুটের কথা বললেন যে যেখানে স্টে হয়ে আছে?
তুই তো নয়। বস না চুপ। মিউনিসিপালিটি।
Trade license latest valid up to September 23.
ঠিক আছে, ফর্ম বের করে দিচ্ছে।
কি করবি? তুই যখন ভাব করে পড়া নিলে তুই শুনাস। এই পয়েন্ট দিবি আমি ভাবি। Unnecessary. Factory is running, this is the report. Though in a different suit.
This is an ex parte local inspection held.
Yes.
Where
But upon
the
notice,
defendants were not present.
Upon notice, upon.
Maybe,
Why
but the
not consent
defendants were not present.
Order is ex parte, but not inspection upon notice.
Why not?
Nobody challenged
I'm
that.
not on the inspection. I only say that this was an ex parte
But
inspection.
all this may be resolved. The companies whose name we have mutated, they should be made party.
It's not,
They'll come and
But
say,
you have shown the record of rights also, I think, in the
yes,
company.
yes, company's name. So there's
There
no,
are
there
deeds,
should,
conveyance deeds, record of rights, everything in.
well, yeah, there should be
company's
made party
name.
and there will be a fight between them and will be.
No fight because you are not challenging the title.
You need to be in possession to challenge.
We are in
the-
possession. We are in possession.
Is it not prima facie
Well,
satisfied?
why they are shying away to make those companies to be the party in these proceedings?
Repetition যেটা হয়েছে যেখানে
And
Will they not be affected if any adverse order
No,
is
it
passed?
was in the past. Cannot be passed here.
Because that will,
Why they are
because,
shying away?
because
Be a party to these proceedings.
It may be that the companies have allowed the bus terminus to
that may be.
No, this is
happen
totally
there.
in my possession. This is the report. These are the documents.
This will not prove here, my lord.
Your document of possession is only your electricity bills.
No, factory license.
Factory license. My lord has not seen.
I have seen trade license, factory license, while granting these licenses, possession is not verified, title is not verified.
Title not verified, possession verified. A factory license has to be inspected.
And companies will play the parties, everything will go.
When there is a
I
full-fledged
cannot
suit
match.
between these two parties, my lord, kindly, my lord, do not make any observation regarding their possession. My lord,
Don't observe, nothing
Those
observe.
possession, my lord, if any comment from my lords, my lord, they will take before the suit
Yes,
court.
should go.
So, my lord, kindly
So
make them, those four companies to be a party to.
Oh,
this
no,
court.
অনেক company. একটা company.
Your suit is against
Against the municipality.
the municipality. On the-
This suit. And the order by which the state government directed me to return the property to the DTs,
That has
that
been
is
stayed.
subject matter of challenge and is
I mean,
stayed by your lordship.
And the subject of master bosses, convenience.
This time I'll bring those on record.
Make them party and they file a supplementary. That will be better. Otherwise, the fight between the,
Kindly test order on rule 10. Are they necessary party, even a proper party?
yes,
Yes, because they also claim to be in possession.
yes.
The record of rights are issued in their
In
name.
their names.
Record of right is
Not a title, it's a position.
I'm not talking about title at all. This court
it's a
cannot
proof
decide
of-
title.
Presumptive value of the position.
I'm talking about prima facie possession.
Prima facie possession is also mine.
So if both the parties have prima facie possession, they need to be added. Let them also come and say before the court.
It depends upon the relief I have claimed.
If you are not in possession at all, sir, if the other party is also in possession, they also have a claim.
Maybe also in possession. I bow down to my lord.
They
They
still
may
have a
have
claim.
also in possession on papers, may have. But nature of the relief I have claimed that the possession, somebody who has no right. I am taking for the timing, those persons have right in possession. I want to remove them who are not at all to be illegally entitled to be possession.
Who are you? This is a question.
I am in possession.
If you have a position, then you right to.
Even the proposed respondents are in possession. Both of you have the same documents in your favor. So let the matter be decided in presence of the proposed respondents.
Yes, yes.
These companies.
I'll give the furnishing the names of companies. Can you do it?
I don't find anybody there, all on paper.
Question of position is not.
No, plan is sanctioned. Every plan,
Let them come before the court and say
No,
they are not in
not
possession.
special officer.
Lordship send somebody today.
Right now.
This is the question. This is not the question.
I have the documents with me. Why would I send somebody? Not necessary at all.
This is the document.
But I provide the names of the companies, they implement them and move it, and they buy a supplementary affidavit. Sorry. Right?
Let me bring on record. Order of the state government by which these were directed to return the land. That has been stayed. If that is stayed,
Within 7 days আমরা করে দিচ্ছি।
wait, if that is stayed, there cannot be any possession by anybody.
There is an earlier order also where your lease has been terminated.
Yes,
And
thereafter.
that order has been
Subsequent
affirmed to
of-
appeal.
Tenancy is running before that. My
So
tenancy
this is,
before that.
this is an order of the tribunal that has been challenged.
I
You are
both
holding
cannot run.
You are holding
you
the
can say.
property on the basis of the lease.
No.
So if the lease doesn't
No,
remain,
no, sorry, man, I should not say no to court. This is the confusion sought to be created. My right emanating from the original owner.
No. I just said, what happened? My lord, Mr. Basu's client, my lord,
জানতোই না তখন।
Ashutosh Sen and Pramod Sen's are my lord, the list that this is Devotha property. My lord, in 1930, Ashutosh Sen and Pramod Sen to the lease. They declared insolvent. Then Ashutosh and Pramod sold to Ram Ranjan Sinha, who subsequently transferred to the GTR. Lease all right. After lease of 1940,
Page 54 of the
Yes,
report.
this is.
Kindly mark
this is
that.
abs-
He has copied from there.
Yes,
My right,
that
my
I-
right is emanating from the
Tenancy.
original tenancy
Not a-
created in my
The
favor.
Shebites, the
By the
Shebites.
Shivites.
Sheba, that is,
Right.
that file the shoot was,
Page 54 of the report, paragraph 3, the entire fact is stated there.
I know the my fact better than them. What is this? My right of tenancy created by the DTs.
Yes.
not it is subsequent lessees, not it is.
Leasehold interest of the lessees was sold.
I became the tenant. My tenancy continues.
That was evicted, title appeal, sorry, man.
Let him complete.
Sorry, man.
Then, my lord, the property sought to be vested. That vesting challenge goes.
So I'm back as a
So-
tenant.
My tenancy right reaffirm.
The Shebites, let us forget the government part. Vesting has gone, so government is not involved.
No,
The
government
Shebites-
Government give me notice.
No, that part is over because that was quashed.
Very good.
That was quashed.
Very good.
The Shebites filed an eviction suit against you. That was decreed.
Decreed.
Appeal was dismissed.
Never executed, This is interesting.
That is a different issue.
No, that is the issue.
They never.
If it is not executed and going to lapse on the prior limitation, what is the effect? My lord knows better than me.
Say 12 years, these are position
Let it
execution.
pass, no doubt.
That should go.
After
The
what the
direction
goes.
for return of the property in the suit you have
That has
said.
been stayed,
My
that
lord,
has been
my lord,
stayed.
Yeah, I'm coming to that.
No, that has been stated because it's sub judice, but there is a direction for return of the
But
property.
that order has been
That
stayed.
stay.
Maybe, but there
So
has
it
been a
is-
direction.
So
Let
that
me-
shows I'm in position.
let
That
me
shows I'm in
finish
position.
Before my lord, that has been stayed.
That shows I'm in position.
Two aspects. One is a decree
Hey.
which has been allowed
Chamber
to be
conferences.
lapsed, not executed. So this is became non-est.
By
I am
virtue
in
of the
possession.
decree, there is a direction for return of the
I'm
property.
coming to that. So today the decree is inexecutable. Decree goes. Now the question is state government exercising power. Where from, I am asking the question to my, what from state government is
Getting the authority.
getting the authority.
State government is not exercising power.
Yes, yes, state government notice. State government says you
My lord,
return.
Mr.
Please, take your seat. আমি কমপ্লিট করতে দেন।
আচ্ছা ঠিক আছে বল
State government issued a notice that you GTR return the land to
The deities.
DTs.
Have you erased the
এটা
notice?
পরে হয়েছে, সেটা পরে হয়েছে।
Subsequently, that has been challenged, that has been stayed.
2 মাস আগে হয়েছে এটা।
Now the decree become inexecutable and the direction of the state government to return the land is stayed. What is the effect? I am asking this question to myself.
এই দুটোর কোনো কাগজে আমরা দেখি
I can bring those.
What about the
Subsequent effect.
documents of the other companies who against whom in favor of whom record of rights have been issued?
If these
You have not challenged those record of rights?
Even state government অন্য কোম্পানি
If
করে রেকগনাইজ করেনি।
If these two documents are before my lord, can be presumed that somebody else is in possession?
Maybe in part, yes, why not?
We'll bring those documents তারপর
Why
যশোর থেকে
not?
Let me bring those documents on record.
Come back, come back.
2 সপ্তাহ
Thereafter.
supplement file করে দিচ্ছি।
But they should be made party by the companies.
No.
But this is my lord, Mr. Basu.
I don't-
Otherwise, then I'll say that Mr. Basu is not.
Let us.
mutation recording malad in their presence, their name were recorded. Subsequently, they did not challenge.
State
No
government-
appeal preferred by them.
State government.
Now they are saying that we are in possession. Well, let those companies be added in the state proceedings.
State
My lord, my Mr. Basu's submission, I say one thing,
Proceedings, anybody enable.
I say one thing, my lord. Can you
State
see?
government cannot
It is
do
a-
anything. So far as this
Mr. Basu,
part is concerned.
can you reply to that?
Without the state government or the municipality, I find that the company, prima facie, they appear to be in
Yes.
possession, if not of the entire property, of some portion of the property.
I will discuss those two documents. Thereafter, you will find
Your-
entire suit property was decreed.
No, my lord,
And decree-
Mr. Basu is not correct the facts, my lord.
Right or wrong, I do not know whether the records
How
have
they
been
can-
challenged.
How they can come.
There
to
are
possession
records,
if
you
the
have not
two
challenged
documents-
them? You have not
The-
challenged the record of rights. Have you said anywhere that they are not genuine, they are
I need not.
manufactured?
আমি তো টাইটেল অ্যাসেট করছি
Need
না।
not. I have not. said
Was it
title here.
initial proceedings?
I'm not talking
Where-
about title at all. Record of rights do not confer title, we are all aware. I'm only talking about possession.
I will
I'm in
demonstrate-
possession.
I will demonstrate you.
You say you are in possession, the companies
will
say they are in possession.
Show that.
I will
It should be
demonstrate.
heard in their presence.
I
This
will-
is my prima facie view. Please come back
Let
with
me
your
try to
documents.
convince after these documents are produced before my lord. Now the,
Well,
what is this? Now it has been,
Madam, Mr.
their campus has been changed.
Mr. Basu, we still want facts. Also, can you appreciate? So I just, sorry, repetition. The 10 acres of land is the name of the deities. Deity leases out it to somebody else. They become insolvent. Then they sold it to a person, Ram Ratan. Ram Ratan sold it to the GTR, Mr. Basu's client. In 1940, that is after expiry of this period, the deities filed a suit. Suit was decreed in favor of the deities. Then appeal was dismissed. This is now kindly pause here. What happened in this moment? State government made the requisition of 4 acres of land out of 10 acres. The GTR vacated the 6 acres of land. Now the dispute will regard the 4 acres of land. Now, thereafter, state government tried to recorded it, the name of the GTR under 44 2A proceedings. And those, yes. And those, then the deities came to the tribunal. Tribunal decided this recording is that was state government moved against that requisition. That was also set aside. Now deities and the tribunal directed to restore the position of the deities. So this is the order. That order was I don't know whether Mr. Basu can
Say that the deities have subsequently transferred the property in favor
to
of
the companies.
So even
So
without
it is-
the state government or the municipality, the crux of the matter is there is a bus terminus in the property in question.
Yes.
Both the petitioners and the companies claim to be in possession.
And then,
I am not saying.
so
In my petition, I am not
Mr. Basu's time, Mr.
I am-
Mr. Basu says,
And it is not a proceeding where the possession is in dispute.
Mr. Basu relying upon the
Some other party also claims to be in possession.
Nobody has claimed, nobody has
no,
claimed.
no, this is
Nobody has
no.
claimed.
Nobody
Nobody has
claimed.
claimed.
Mr. Basu is relying upon the state government's action. State government says the state government has recorded it
Let
as a
me
cost.
also come back with the supplementary affidavit. Prima facie, I
If-
am of
if
the
one
view
only
that
thing-
they have to be
Question of
added as parties.
civil,
Yes.
civil law, if the decree.
No, I don't know whether it's executed or not.
Incorporated,
Mr. Basu
I am
cannot say.
Let us forget about everything else.
I am in
Two
possession.
separate individuals claiming to be in possession of the property.
No, company has.
You
not
are
claimed
claiming to be in
possession.
possession, the company, the documents say that the company also may be in possession. So if that be so, they have to, the matter has to be heard in
My
their
lord, my lord has
presence.
to look to the genesis. Entire land belongs to me.
No, you not the deities.
Please.
Entire land belongs to me as a tenant. Suit for eviction decreed. Allowed to be evaporated. Still, I am in possession. Nobody else can be in possession.
It is not improbable that the DT, since the decree of eviction was passed against you, the DTs have subsequently executed
Yes,
tax deeds in
yes.
favor of the companies.
That is
Yeah.
Let them
Allow
come.
with me.
What is
He
the
can sell.
difficulty if the companies come and
He can
place
sell.
their cases?
He can sell. DT can sell the property. I cannot stop it. DT can sell the property, keeping me as a tenant in the
Why?
property.
Why? That is the lease expired. It was decreed. What Mr. Basu is saying, because he's saying, no, you don't know whether it's executed or not. Mr. Basu is not.
Need to be added. You
Decree
can
is
come back
knowledge.
with your supplementary affidavit.
Yes,
Let me
yes.
come with a supplementary affidavit, then I will.
And
I will
make
start.
them come.
Proper assistance will come from those companies.
Those
We don't
companies are
know
poor.
about those.
I'll provide the particulars of the companies, man.
Heard learned
And
counsels
it
for the
does not shoot in
parties.
the mouth of the state.
The petitioners
He is nobody.
claim to be in possession of the property in question. Stop.
State flag government or private?
On the
government
contrary,
flag
comma, the report in the form of affidavit submitted on behalf of the fourth respondent contains mutation certificates and record of rights, which prima facie suggest that some companies are in possession of the property. Paragraph learned counsel for the petitioners seeks to use a supplementary affidavit in this matter, annexing relevant documents. Paragraph, let the matter appear under the same heading on 6 September.
Are to show.
You'll need little more time.
And following week.
2 weeks.
13.
My lord, kindly gives us two more further weeks.
15th September?
15 September.
Yes?
I can't say now the enter.
You can
we-
take back the document of the suit.
I'll provide the particulars of the companies.
Not necessary. No, let them come back. Let us hurry the matter. Let them come back.
ওরা কোম্পানি থেকে বলছিস কেন? What is your interest about the company?
You are altering of the company.
হয়ে গেছে।
Item 7.
Thank you, madam.
Deeply honoured.
7.
I am.
Oh, you're there.
নতুন আইটেম আছে তো?
But this is not travel lordship. This is twice they have taken time.
Who is appearing?
Mr. Day is there. No problem. My lord, kindly come to the impugn order at page 99. Salt Lake Properties, in terms of the will, you are bound to record my name. That has been settled with the division bench. I have handed over to your lordship. এই জিনিস তো একদিন বলনি কেন? ঘুমাচ্ছিলে কেন? এটা কোনটা দিয়েছে? My lord is looking 16693.
16693.
93. Yes, can you come to 99?
Oh, there are two matters together.
না না, Salt Lake Properties settle হয়ে গেছে।
Page 99.
Page 99.
My lord, I have no page 99.
Yes.
তোমার কি হবে?
No
লাগবে না।
page 99.
ভালোই তো পড়তে হবে না একটা পাতা।
Even I have no page 99.
হ্যাঁ?
Page 82 is the last page.
কোনটা দিয়েছি? এই সেটা দেখ না কোনটা। Second 16693.
Oh, 99 is the second matter.
সেই জন্যই মিলছে না।
No, no, no. There's a mistake. Give a minute. please.
হেল্প করো, সব একসঙ্গে হয়ে গেছে। দেখ স্টিকার। দর্শককে দেখ সব চড়িয়ে মুড়ি একাকার হয়ে গেছে।
সেকেন্ডটা উপরে চলে এসছে। থাক, ঠিক আছে। Yes.
But kindly come to 99. I need not read the second paragraph. Third paragraph can read. Enough. আমার লাগবে না, আমার মুখস্থ এই মামলা। পড়ো।
So they have not accepted the transfer.
Now, can you see the judgment I have handed over? Law is settled. দেখি পাতাটাকে বলে দিই। 417.
Please give the reference to Mr. Give the reference to Mr.
Reference, yes, he knows. 191 CLJ. তোমার লাগে না। 191 CLJ 417. Copy নেই তোদের?
The relevant paragraph?
This is the entire judgment is on this point because will is a transfer subsequently, not a transfer in present time. So it not that is clock is not there. After this judgment, this lot has been settled. Before that, my lord, there was divergent views. Elaborate. অনেক খাটতে হয়েছে। খেটেছি তার খোঁজা নিচ্ছে এখন, গাছ পুঁতেছি এখন ফল পাচ্ছি। আমার সঙ্গে বলবে তো আমাকে
In this judgment, was it in favor of someone who was not a member of the family?
Kusum Agarwala. Now, can you see the name? And the allotment.
Please show me the relevant portion of the judgment.
But the entire judgment is relying on Kailash Kapoor.
No, no, to show that he was not a member of the family.
Oh, not in the family, not at all. I'm showing to you, he's a stranger to the family. Because the allotment in the name of a Bengali person, and the will was in favor of Rakhal Chandra ki naam na?
Rakhal Chandra Kanjilal and Company.
Yes, it was Rakhal Chandra Kanjilal is the original allotee.
আমাদের টাকা ও ওটাতে আলাদা আছে
এই যে অজিত চন্দ্র বাগচি is a Bagchi family, paragraph 3.
Yes, well, kindly come to paragraph 3, you will find Ajit Chandra Bagchi.
Yes, Mr. De.
Law is settled now.
My lord, law is settled that I want to see my lord. When my lord, your lordship. 1 week time.
Sometimes it has been adjourned.
It was adjourned on different grounds.
Yes.
The panel changed and.
Panel change prior to that, I showed this judgment, he said accepted. What is to see, I don't know.
Let him go through the judgment. You are giving it here and now, so let him go through it and come back.
Yes, what should I say? This is but a reported judgment, not an unreported judgment.
No, but still he has to go through the reported judgment.
He is appearing in the state matters, in the land matters, so he is supposed to know this.
All the judgments by heart.
Because he is confined to land matters only. But give me a short date.
Yes. On prayer of the state respondents, the matter is adjourned. The matters are adjourned. Paragraph, let the matters appear under the same heading on 30th August. Next week.
As early as possible, subject to my.
30th August.
30th को रखो ना 30th पे रखो ना तो हमारा सुविधा
পড়ে দিন আবার
1-2 তারিখে যে কোনো দিনে
1 তারিখ
my landlord will not be here if possible first.
Very nice. 1st September.
Copy দিয়ে
Will
দিলাম
you please give a copy of this or you'll bring your book again down?
already hand over আমি দিয়েছি already
ওটা ফাইলে রাখো ওটা ফাইলে রাখো
September
হ্যাঁ 1st September.
আমি খোঁজা পারি না জজ সাহেব খোঁজা পাচ্ছে আমার ভালো
Next.
Item 9.
For the petition, your lordship. On the last occasion, the state was, the national highway was supposed to take.
I need, my lord, another 1 week time, my lord. I need at least my last chance, my lord.
Already took extension for.
My lord, as a last chance, my lord, if I fail lordship, then lordship is pass the necessary
He's
order.
appealing for the state. State doesn't need to file a report.
I don't know.
What is the issue about?
Your lordship, the issue can be dealt, this is a second round of litigation. Initially, I came before your lordship, the lordship directed, I have been before the competent authority. Rightly or wrongly, now they have passed a 3G1. They have given me a copy. I have made a representation before the arbitrator. Now, basically, my remedy lies before the arbitrator.
Yes.
But arbitrator has not considered that, so I am before your lordship. If a direction given to the arbitrator to consider my representation under the arbitration and consideration.
PG5.
Yes, under second. That can be resolved because nothing more.
Yes, lordship, I have no objections on that, lordship. I don't even know much whether the arbitration procedure has been initiated or not, my lord. This is my only instruction, lordship.
He has not received notice.
Nothing has been received.
My lord.
Page number 104 is arbitration application.
Even if it is initiated, you know how it is initiated and how it is disposed of.
Your lordship,
My lord, that I can't make
your
any
lordship,
submissions on these, my lord.
yesterday I have been to an arbitration proceeding in the North Chobbish Pargana, your lordship. More than 800 persons were there. Everyone is sitting on it. They have hired a auditorium and the arbitration proceeding is continuing.
Wonderful.
I don't know how
And
this is.
ending with lunch? No?
Not for us.
Not for us. Acha.
Page 100.
104, your lordship. Respondent number 6 is
Can
arbitration.
this be considered under 3G5?
Yes.
My,
Yes.
if your lordship kindly record it without going into the merit, my lord, that will, I'm grateful.
3G5 fresh হবে তো আমার তো তাতে কোনো
অসুবিধা নেই, আমার কথা হচ্ছে হয়ে গেছে কিনা আমি জানি না, আমি প্রসিডিংসটা হয়ে গেছে কিনা আমার ওই ইনস্ট্রাকশনটা দরকার ছিল।
Respondent number 6.
Respondent number 6 is arbitrated, your lordship.
The petitioner is aggrieved with the the compensation granted to him under section 3G1 of the National Highways Act 1956 and has filed an application before the learned arbitrator on 6th May 2022 for consideration of the same, for consideration of enhancement of the compensation. Consideration of enhancement of the compensation. Stop. The said application is yet to be considered. Stop. The petitioner prays for a direction upon the 6th respondent to consider the application in accordance with law. Paragraph upon consideration of submission made on behalf of the parties, comma, the writ petition is disposed of, directing the 6th respondent to consider the application submitted by the petitioner dated such and such and pass a reasoned order within 2 months. Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the learned arbitrator shall be communicated to the petitioner within 1 month thereafter.
Deeply obliged.
Paragraph, it is made clear that this court has not gone into the merits of the case and the learned arbitrator shall be at liberty to deal with the application of the petitioner independently in accordance with law. Disposed of.
Deeply obliged, your lordship. তারপরে দেখলাম 800 লোকের arbitration করে এসেছি।
Item 11. And I am for the petitioners.
And I appear for the respondent, West Bengal Industrial Development Corporation. Respondent number 4, 4, 5 and 6.
We now have this state.
Okay. Also, I appeal for the state.
My lord, in this matter, I have made representation for allotment of 4 acres land, which is lying vacated under the WBIIDC. For setup of a cold storage, my lord. My land was also acquired by the government in the year 2005 and several other Gujarat Ambuja Export Limited set up in that land and 67 acres land set up their industry, my lord. And accordingly, for the business purpose and for the betterment of the village people, my lord, I have made representation before the authorities to allot me the 4 acres land for the setup of a cold storage, my lord. And I have made several representation. But once I was called for hearing, but the authority did not pass any order, my lord. And I have made last representation on 28th October 2022. My lord, my prayer is to consider the representation for after giving me the hearing and pass the reasoned order.
Where is your representation?
My lord, page number 38, my lord. P5, annexure P5.
Yes, let this be considered.
Lordship, consider the reprint.
The writ petitioner, the land for which the writ petitioner has applied for allotment, well, that land has already been allotted to a third party. And possession given, the entire lease premium has been paid.
The entire land?
Yes, my lord. Because the application has to be made as per the land policy guideline. It has to be online application has to be made along with all the supporting documents, which the writ petitioner did not do.
So it was allotted in favor of others?
Yes.
Who made a proper application?
My lord.
Right.
And it has been done as per the procedure laid down in the land policy.
My lord, the representation is pending, my lord. Initially, there are several representation made by the petitioner. Initially, hearing also taken by the authority, competent authority, and hearing taken, but the order was not passed. Thereafter, further representation filed by the petitioner, but that is pending. That is annexed P5, my lord. Kindly give direction to dispose of this representation.
The authority says that the entire acquired land has been allotted to some other people.
No, my lord, so far as my information is, my lord.
So in that case, it has to be your representation, no use, isn't it? It will be rejected.
The possession certificate and the payment of lease premium, this everything is here.
Our only prayer is only to dispose of this representation by giving
that document is
opportunity of hearing to all the interested parties.
Gujarat Ambuja.
Yes, ma'am.
Gujarat Ambuja has been given 67 decibels. That is the case of the petitioner. Out of 88.
Yes. Out of 88. Only to dispose of this representation by giving an opportunity of hearing to all interested parties. That is my prayer.
My lord, I have handed over the possession certificate also. From the possession certificate,
This is
appears
8.42 and 0.40.
my lord, the possession certificate, the area of the land is 8.42 acres.
Yes. That is not the total area.
Yes, that has been handed over. My lord, kindly see the possession certificate which has been
8.42 is not the total area of the land acquired.
no 8.42 is the area of the land which is available.
Which
was available.
Which is allotted. So
Which
there is some other land.
No, my lord. This is the land which was available and it was been now allotted. And this is the land for which the writ petitioner has applied for. Writ petitioner has applied for a particular area, portion of land.
Plot number 329, 330, 331, 332, 337, 338, and 44, 88. No, 44.
And this is the land which was allotted.
What is the plot number of the land that is allotted?
LR plot numbers 316F, 319F, 1004F, 1003F,
331F, 330F, 329F, 337F, 324F, 325F, 326P, 338P, 332F within the Mauja, Mandilpur. Well, kindly see, this is the possession certificate which was handed over to Gujarat Automobile. Thank you.
What's the presentation?
Petitioner first made representation on 4th May 2022.
The issue is different altogether, madam. They say that the entire plot acquired by them has been allotted already. So how
It
can
may
they
be
allot-
allotted after the representation made by the petitioner, my lord. The competent authority had taken the hearing but not passed any order. They may reject
The representation, because on the basis of
You have to
representation,
challenge the allotment in that case. Your representation will not
No,
help.
we have not challenged the allotment. Only made representation to
Your
consider our
representation
case.
will be rejected merely only on the ground that there is no plot left. What is the
It
use?
was not rejected, my lord. No order was communicated to us.
Will be rejected if this is sent for consideration. The authority already says that the entire plot has been allotted. So what is the use of sending this representation? No use.
My lord, when it was allotted, my lord,
That is
when
not the
petitioner,
subject matter of the writ petition.
my lord, when petitioner made the first representation, at that time the plot was not
So in
allotted.
that case, if you are aggrieved by the allotment, you have to challenge the allotment. Isn't it? In this writ petition, there is nothing.
That was not within our knowledge, my lord. When we made the representation before the authority, the
Representation cannot be
plot
sent
was
for
not allotted.
consideration because the authority says no use. Why should I send it for consideration when the authority says there is no plot left?
My lord, kindly direct my learned friend to give me a copy of the report, which is submitted before this honorable court.
I will give a copy. Because the according to the land policy, the application for allotment of land has to be made online in a prescribed form.
That has not been done. A
No.
representation will not help, isn't it?
On the basis of representation, we cannot allot any land.
So nothing remains, it has to be dismissed. Your writ petition.
My lord, kindly give me some time so that I can take instruction from my client that is there any other land which was not allotted to any person.
Will it
It is
really
now-
improve your case when the authority says there is no other land?
Well, in
Kindly
case
give me 2 days time.
my
my lord,
la-
only 2 days
I
time.
can make a suggestion, madam. If my learned friend wants another land, she can apply as per the procedure laid down. If any land is available, other land is available, she may be allotted.
Yes,
But
my lord, kindly
but
give
for
me
the
2 days
particular,
time.
Take little time, let her come.
2 days time only.
So in that case, will you come back with a report instead of filing these documents like this? Because I'll consider the application on the basis of these documents.
my lord, I shall come with it.
Yes.
Lordship.
Affidavit of service.
A report in form of an affidavit.
Affidavit, yes. Learned.
From the collector, my lord.
No, because they have allotted 4, 5, 6, 7.
Lordship.
4, 5, 6, and 7.
Yes, madam. The West Bengal Industrial Infrastructure Development
Yes.
Corporation.
The petitioners seek a direction upon respondent numbers 4, 5, 6, and 7 for allotment of plot which was acquired by the government and made over to these respondents. Stop. Paragraph, learned counsel for the respondents submits that the entire plot made over to the corporation has been leased out,
Yes, yes. Allotments are on basis of long-term lease.
has been allotted in favor of Gujarat Ambuja Export Limited,
Yes, ma'am.
in favor of Gujarat Ambuja Export Limited, and no portion of the plot is no portion of the plot remains for allotment in favor of the petitioner. Paragraph, learned counsel for respondent numbers 4 to 7 seeks to submit a report in the form of affidavit in this regard. Paragraph, learned counsel for the petitioners also seek accommodation. Paragraph, let the matter appear under the same heading on 4th September.
Grateful, my lord.
But instead of the entire land, because I also have to take instruction, other land is available. Instead of allotment of the entire land, it's, let it be the land which was applied by the petitioner. That was allotted. That is my instructions.
কি বলে ওই জায়গাটা? Submitted. তার আগে submits that. দিয়ে দিন। Numbers 4 to 7 people submits that. That এখানটা করুন, the plot of land requested to be allotted in favor of the petitioner has already been allotted in favor of. But to the বলেছি।
Thoughts? Grateful, man.
No, ওটা দিয়ে দিন, উনি একটা report. Please, you can take back these documents.
Fine.
Because you'll come back with the report.
Affidavit of service, my lord, is kept on.
Yes, take it.
My lord,
Huh.
in the matter, my lord,
12 o'clock, yes.
they have already started demolishing.
947 from monthly list.
I received this. They have already started demolishing. I have received the information from that place.
Yes. Respondents,
Mr. The day is appearing.
কত নম্বর এটা?
947.
947 from monthly list fixed at 12.
I have received.
have you informed the respondents that?
Yes,
it will be
in
taken up?
office. I
It
received.
will be taken up at 12.
I have informed the respondent there. SDO received the same that this matter will be taken up.
You have informed who?
My lord, the matter relates to
Please give me a minute.
affidavit of service. Kindly see the affidavit of service. The respondent refused.
The private respondent also, have you served?
Yes, I have served by speed post. I think 1 month before. I was refused to take service
Where
on.
is the service on state? Where is the?
I have service. From the office I got. From the office I received that Mr. Day has been allowed in this matter. Just now.
You filed the writ petition on 12th July.
Yes.
Today we are on 22nd August. Service is not complete as yet.
Service
Not complete.
Why, my lord? I
The
have.
state is not informed. The private respondent
It is
service.
informed, madam. It has been served. Yes, sir.
GP's
What's
office.
not served? I have served.
I must come with the file.
This is the difficulty. You have
No, I have-
mentioned upon notice.
No, I have received, given notice from the GP office.
GP office is, so let us wait for the GP to appoint.
No. They have already informed, Mana. They have appointed Mr. They. Just now he came to know.
Mr. Day is not informed.
I don't know what they have
The
said.
private respondent is also not there. And this is a suit of. Yes.
I have mentioned yesterday. I also told him. I mentioned the matter. Well, I have not been given details. He said. এই ম্যাটার তুমি ঠিক আছে বললাম তোমাকে বলেছি মেসেজ করেছি আরে অফিসে বলেছে তোমার নাম
ঠিক আছে আমাকে তুমি নোটিশ দিয়েছো
কালকে মুখে বললাম তোমাকে
মুখে বলতে হবে বলেছো 947 দেখে এসো
অফিস থেকে বলেছে
নোটিশ নেই মুখে বললে হয়ে গেল না
অফিস তোমাকে দিয়েছি তোমাকে পার্সোনাল নেবেন মানে হি ইজ ইন দিস ম্যাটার মানে জাস্ট আই কেম টু নো ফ্রম দ্য অফিস নোটিশ দিয়েছি দিয়েছো এখনো অফিস নেই তুই বললে যাইনি
Which order are you challenging?
Of the DM allowed at page 19th April 2023.
Page?
And this is the page. DM's order. Page 161.
Yes.
Page 161. And this is the order.
Yes, an absolutely reasoned order has been passed. You were heard by the DM before passing the order. So what is the difficulty?
No,
You have been
order.
held to be unauthorized encroachers.
No, my lord. Can you see the order?
I've seen the
challenged this
order.
order.
Yes.
Yes, see. Can see this. The
Your submissions were taken into consideration by the DM.
My first question is the land has been acquired for the public purpose. First question. It seems that from the action, the land has been acquired for the private purpose, showing it in the garb of public purpose. And Jyotish Chandra Mondal, the person residing just behind my land, and there is a passage to enter ingress and egress.
Yes, please use the microphone.
Ingress and egress from and out of his house. Now, my land is on 1057 decimal 567 and plot number 1355, dag number. Now, some portion has been acquired by the land acquisition, they say, for the widening of the road. Road has been widened. My land has been acquired, excess. Now, some lands are still there. Now, I have been doing business in just side of the road of HON'BLE Rhinosphere, my maternal uncle. Because he gave this land for the purpose of unemployed youth to use his land as building a shop in the year 1970. His father gave Aurobindo Rhinosphere. So we have been there since 1970. And the electricity consumption will Panchayat tax, rate tax, all are given by the government. Now, so there is no interruption, nothing else. I've been they are widening the road, no problem. Now, Jyotish Chandra Mondal, who is residing behind the land of my maternal uncle, he has some some quarrel with this brother of this landowner, Sundaban Ranaskar. Now, this is some problem with Judicial Mondal and these petitioners. He took a vow that I have to evict you anyhow. What he did, he engaged, he just took the lease of Selami, a particular balanced land of Sundaban Ranaskar from the as Mr. Jyotish Chandra is not going in his residence and coming back in case of being obstructed.
That is not the only ground.
That was his main ground in his writ petition. Jyotish Chandra Mondal. You see, I can produce the writ petition.
The order says otherwise. You have encroached upon PWD land.
He has written that, but that is, can you see the writ petition of Jyotish Chandra Mondal?
Maybe, but you have.
I have not encroached. I have been made encroacher by the acquisition.
Yes,
I was there.
After the acquisition.
So I
you are
was
encroacher.
not an encroacher.
After the acquisition, you are encroacher?
No, how could encroacher
After
means
the acquisition?
he made me, but I was not an encroacher. I was there since like 50 years.
After the acquisition, you should have left the property. You have not done that. A very recent order, a joint inquiry was held.
No, that land is not being used for public purpose. What is the public purpose? Can you define in public purpose?
Not necessary at all, sir. Only
Yes.
the only thing is you are encroaching. What
No,
does
no.
section 10 proceeding mean?
Since that proceeding is absolutely illegal, because proceeding must be done for the public purpose. This acquisition for the public purpose we have taken. Now it is being used for the private interest.
That is a
That cannot
different
be
issue.
done.
That is a
That is the
different
issue. I have challenged this. Points of law here involved. Can you see the?
So
can you see-
please serve and come back. No
Why
protection
not?
can be granted to you. It's a very well-reasoned order. Passed
Well,
in your presence.
well,
You were heard. by
The
the
status to
authorities.
do maintain, let the file and affidavit and decide as early as possible. What's the harm? We have been there for the last 50 years. My right to life livelihood has been taken up.
Please serve and come back.
I have served. I have served.
Where is the service on the private respondent? Please show me.
I have sent the
Sending is not service, sir. You are
speed
aware.
post, peace post.
Where is the return? Please show me that you have served, not sent.
No, I can give you track record, my lord.
Please show me the track record. This is not an affidavit at all.
But private respond in anyhow were not disturbed. I have been disturbed by.
You have been in.
My livelihood has been taken away. How it could be, my lord?
Then impleaded.
But I have filed this 2 months back.
Is it there? Is there? No. Because it has been served on the state.
Yes, 2 months back.
Mr. HON'BLE, may I request you to appear? This is against 10-4 order.
What else they have served on the office of the government?
Yes, they have served.
They have got to have served on the government advocate after asking.
I have just nothing to do, Mr. This is appearing.
And service upon the private respondent is also not there. Please come back with the service.
No, I have served. I should give the track record. I have
Yes,
served by speed post. Sir.
that is issuing, sir, not service.
But he is not anybody. I have served. I will come out.
Please serve and come back. I'll fix a date. Prima facie, it's absolutely a legal, justified, reasoned order. So I.
I will show that is absolutely Absolutely wrong. Absolutely
Oh.
wrong order.
Affidavit of service. Paragraph, none appears for the state respondents. Paragraph, since service upon the private respondent is not complete, comma, let the matter stand over till 4th September.
Proceed. In the manner that they stay the demolition. But then if it is demolished, then my entire livelihood will gone. In 4 or 5 days, nothing. I've been there last 50 years.
You are encroaching for the last
No,
50 years.
I am not encroaching. I'm still, I am not an encroacher. I filed this in June.
Please come back after service.
Kindly status quo to be maintained. For
Yes.
5-7 days, nothing. I have been there since 50 years. My shop room has been managed. My library.
Considered your 50 years and all.
Well,
have been
if they
considered by the
demolish my entire shops, all stocks, goods are there.
It will be stayed till the adjourned date.
Lordship.
Paragraph 4. Since the order, since the order impugned passed on 19th April 2023 is due to be executed this day, comma, the said order be stayed till the adjourned date.
Yes.
Next.
Item 12 from days list.
I beg to appear for the petition.
Yes.
I beg to appear for the Am I available of service? State are the answering respondent, my lord. The one of available.
নিচ্ছি একটু দাঁড়ান ফাইলটা দিই
There are some performer respondents I have not served. We have the similar cause, same cause of action. May I please your lordship, my lord?
Only state?
Yes, my lord.
It's appearing, what about? Yes.
So one of case. Now, my lord, the petitioners and the performer respondents are the owners of the land, a particular plot of land by way of purchase. Now, 5 years after their purchase in 778, under an LA case, the middle portion of the property owned by these parties were excavated for the purpose of constructing a canal. Now, at that point in time, there was no compensation awarded to the petitioners or the respondents. Now, my lord, we preferred a suit. Now, my lord, the suit was for preliminary for declaration and permanent injunction along with damages. Now, my lord, kindly comes to page 27 of my brief, my lord.
Yes.
This is the decretal portion of the suit. State where the parties there. May I read it out, my lord? The suit be the same is decreed on contest without cost against the defendant number 1 and ex parte without cost against the rest. The plaintiffs do get a decree of declaration of title of the suit property. Plaintiffs do further get a decree of permanent injunction restraining the defendants from interfering with the possession of the plaintiffs in the suit property. Now, my lord, the operating portion, so far loss and or damages due to non-production of corpse on account of excavation the plaintiffs are entitled to recover the loss and or damages by a separate proceeding upon payment of requisite court fees before a proper forum in accordance with law. Now they prefer an appeal. The state prefers an appeal. Now page 45 is the operating portion of the appellate court judgment and decree.
Yes.
In the ordering portion, ordered that, may I read, madam?
Yes.
That the appeal be the same is allowed in part on contest, but without cost. The impugned judgment and decree passed by the learned court below as regards declaration of the plaintiff 16 annas title in respect of the suit property is hereby affirmed. But as regards decree for permanent injunction is hereby set aside, and the rest portion of the decree towards loss and damage as passed is hereby modified to the effect that the plaintiffs are entitled to compensation from the defendants in respect of the portion of the suit property covered by the canal. The defendant are hereby directed to pay compensation to the plaintiffs in respect of their lawfully occupied portion of the suit property on ascertainment of the area of physical verification and also observing all the formalities which are required under the LA Act in order to make payment of compensation to the claimants, I mean the plaintiffs, within 4 months from the date of decree, failing which the plaintiffs will be at liberty to take steps against the defendant in accordance with law for realization of complement. It is hereby declared that so long the payment of compensation is not made, the plaintiff 16 annas title in respect of suit property remains intact. Now there is no dispute of fact. Suit filed by us, decreed, appealed by them, all the disputed matter of fact has been settled. I filed an execution case in the year 2004. Now, my lord, 180 orders have been passed by the executing court. Till date, not a single scrap of report has been filed. And they admit by a memo filed before, my lord, the government officials were directed to be personally present. They were with memos. My lord, in one of the orders, it was recorded that the amount of compensation was in surplus was lying at the office of the department. My lord, that order is order number 170, page 61.
It's a prayer in the repetition.
My lord, I understand it. My lord, this court is not in executing of a decree passed by the court below. Now, my lord, I have specifically prayed for compensation, payment of compensation.
That is in execution of the.
That is in execution for the last 20 years. I knew that they would have taken a chaya of maintainability. Now, my lord, in the recent judgments, my lord, there's Supreme Court has taken this cognizance and directed that for them to pay certain amount, so that and the rest amount to be paid upon conclusion of the execution proceedings. They cannot delay the payment for more than 50 years. My lord, kindly, I stated, my lord, this is a one-off case. 77, 78, the land was taken. Till to this date, not a single penny paid.
For expeditious disposal, it's a
No, my lord, that order is there. That order.
matter, no?
Now I understand that order is there already by Justice Sarkar, my lord, already passed an order of expeditious disposal. Till to the, my lord, kindly, there was a time frame. They have not till to this date filed a report. My lord, kindly for once come to page 61. Since there is no dispute regarding facts, that is why I am before your lordship. Humanitarian
Yes, page 61.
61. This is the order number 170 of 2021. My lord, kindly sees the para from the top, para 3. It is specifically admitted by the ADM LA Nodia, by this letter bearing memo number such and such, that a substantial fund is available with the INW department to the tune of rupees 32,16,000, and the following portion of the letter of the MLA is reproduced here. And in 20 years, it took them one memo which is filed before the learned court below. Until to this date, not a single penny has been paid. All I'm praying for, my lord, let them. No, my lord, the execution proceedings.
The order of this court has been violated.
My lord.
The order of this court has been violated.
The order of.
The direction for this expeditious disposal.
I cannot file a contempt against a judicial officer, my lord.
Then suffer.
No, my lord, I understand. I say 50 years.
I have chosen to suffer.
No, my lord, I have not chosen. I have been litigations, my lord. One set of legal airs are already expired.
Court give a direction for
to secure a certain portion of the money before the executing court below and conclude the proceeding in a certain time bound manner, my lord.
under what provision?
My lord, may I rely on him?
You undoubtedly have a very good case, but then the
My lord.
forum.
My lord, may I please, your lordship, for once, bears with us. My lord, kindly sees para 2 of the judgment, my lord. A similar case, execution proceedings filed, still the Supreme Court directs the state authorities to pay a certain amount of money. So 1-page judgment, my lord.
Compensation amount has been assessed.
No, my lord, it was initially, my lord, they have not filed a report as to that effect. My lord, kindly consider appeal disposed of. There is no disputed matter of fact. Still to this date, not a single report.
Because here compensation was decided,
My lord,
still not paid.
still composition, my lord. My lord, kindly directs them to file at least a report before your lordship. And if I'm prima facie satisfied, your lordship, on that, my lord.
That's exactly what I said. You have a very good case,
My
no
lord.
doubt. But then, yes, Mr. Mandwani. Yes.
So what is
Pay the compensation, sir.
Well, it is correct, my lord. These, my lord, the compensation amount should be paid, my lord. The execution case is pending. There is an order, my lord, passed by the learned
In
court
the
below.
execution case also, you are not taking any
But in
steps.
spite of that, the authority has not yet paid. But it is correct, my lord. Now let me take instruction to
Yes,
the.
please come back with the report indicating the amount of compensation.
I'm grateful, my lord.
Only question is this, my lord, the land acquisition proceeding has not been initiated.
Uh,
It is not the case, my lord, the land acquired or not.
All
This
those
case is
parts are
this, my lord,
All those are decided in appeal and suit, my lord.
His case is this, my lord, his land, my lord, utilized, excavated the earth. Thereafter, my lord, a damage compensation has been, my lord, assessed.
And you have not challenged. No, the challenge was turned down.
Appeal, my lord, the court, my lord,
Turned down, yes.
appeal court, my lord.
No second appeal. Attend finality.
শেষ করি না তুমি তো বলেছো দর্শক দেখিয়েছো
Sorry.
modified the order to the extent, my lord, the interim order passed, my lord, to be extended, modified to the extent, my lord, permanent injunction set aside.
Finally, there is a direction for compensation.
My lord, that is the only good question.
And an execution proceeding is pending where the state is not taking any steps.
My lord.
আরে আমরা তো স্পেশাল কি করে দেবে ইরিগেশন ডিপার্টমেন্ট তো ব্যবহার করেছে ইরিগেশন টাকা না দিলেও
Since you have not challenged the appellate forum's order, you are left with no other option. You have to pay. Please come back with a report, Mr. Mandwani.
Come with the report, my lord, by the irrigation department, my lord.
Yes.
The irrigation and waterways department, my lord, forwarded a letter to the higher authority for, my lord, the disbursement of the fund. This is not sufficient.
Interdepartment tussle have been engaged in.
You should have filed a contempt application.
Against a
That could have been fruitful.
not the practice of the court, my lord. Before against a judicial officer, my lord.
Judicial officer কি করে
Contempt to sir,
এরা জুডিশিয়াল অফিসার কি করে হবে
lower courtর উপর direction expeditious sir. সেটা হয়নি।
You communicated the order to the lower court.
My lord, they recorded in the order itself that the order has been passed on the every date. The learned court below records that there's an order from the high court. Still, there's nothing progresses, my lord. They chose to appear some days, they choose not to appear some days, they say that money is there.
Extension of time has also not been prayed for.
No.
also to.
One-off case, my lord. This will not create a precedence, I'll pray, my lord, but this is a one-off case. 50 years I've been without compensation.
I do not know how far this court can help you. Let this, Bandhukata come back. Affidavit of service. Paragraphs, the petitioners. That the petitioners along with the performer respondents are recorded owners of the plot in question. Sometime in 1977-78, the state respondents excavated earth in some portion of the for digging a canal the petitioners learned that the plot was acquired by the state with a LA case number 50 within bracket R, capital R, bracket closed, /77-78. Stop. The petitioners filed a suit praying for declaration and injunction, which was decreed by a judgment passed on the judgment in the suit was passed on.
My lord?
The judgment in the suit was passed on.
The judgment and decree in the suit passed on, my lord, 21st of February 2000. My lord, para 7, page 6.
On 21st February 2000. Stop. The state authorities carried the judgment and decree in appeal and by judgment dated 29th June 2002. The
My lord.
judgment
My lord.
dated 29th June 2002, comma, the learned appellate court allowed the appeal in part and directed the state respondents to pay compensation to the present petitioners
And the performer respondents, my lord.
and the pro forma respondents in respect of the unlawfully occupied portion of the property on ascertainment of the area upon physical verification and observing all formalities under the Land Acquisition Act, comma, within 4 months from the date of decree. Stop. Paragraph, learned counsel for the petitioners submits that such compensation has not been paid by the state respondents till date, despite an execution case pending against them. Stop. by an order passed on 6th April 2021 in CO 677 of 2021, a coordinate bench of this court directed the executing court to dispose of the title execution case within a period of 4 months from the next date fixed before the court. Despite which, the execution case has not been disposed of, let alone any compensation being paid by the state respondents. Paragraph. Learned counsel for the state respondents seeks to submit a report in the form of affidavit in this matter. Please ensure compliance, Mr. Bandipata.
I'm
There's
trying,
a limit.
I'm trying, my lord. It has been assessed, my lord. I have shown my learned friends.
It has been
The
assessed.
fund has not been placed. Therefore, my it has been placed.
For such a long period, 50 years.
Only 1,81,000 is my the lying with the hands.
You have to pay
But it
interest
has
for
been
all this.
assessed 33 lakhs.
33 lakhs entire amount with from that period of time.
But that amount has not.
And you have to
Due
pay
to
interest.
non-placement of fund by the irrigation department.
Please instruct your authority that they have to pay interest on
I
this
shall
account.
try.
I'm grateful, my lord.
Paragraph, let the matter appear under the same heading on, then will you come back?
Any day convenient to lodge.
5th September?
I'm grateful. ma'am.
Tuesday. Yes.
অনেকক্ষণ আছে।
6. 13th.
I'm good. I'm grateful.
Next. Yeah.
13.
My lord, I am for the petitioner, my lord, in this matter, my lord. There is a typographical mistake in synopsis, my lord. There is written as pump house, my lord. But, my lord, kindly ignore, my lord, that, my lord. In the writ petition, my lord, I have stated that I got the property in the year my predecessor in interest got the property in the year 1955, purchased it. Thereafter, under West Bengal Estate Acquisition Act, the record of rights was finally published, and in that record of rights, my predecessor's name is there. Now, my lord, kindly come to straight away to P1, that is at page 34, that is the deed. 34 onwards. Then, now, my lord, kindly come to page 50 and 49 and 50. That is the record of rights under West Bengal Estate Acquisition Act. And there, my lord, at page 50, my lord, kindly see on the right hand side, my lord, on the left hand side, Rayati Halim Ennesa Bibi. Then, my lord, underneath of it, Madhusudan Guho. That is my predecessor in interest, and on the right hand side column, Otro Sottet Shreni Ebong Bishesh Niyam Anusare Rayat Sthitiban. So I was Rayat in possession. Thereafter, my lord, I have paid the Khajna. Next page, that is at page 51. My lord, thereafter, my predecessors, my lord, came before this writ court, my lord, that is at page 52. In that writ petition, there were several orders. That is at page, kindly come to page 83 once. Initial order was passed by Honorable Justice Dipankar Datta.
83.
83.
Yes.
Where Mr. Ghosh did appear, Mr. Ghosh, learned counsel for the corporation, shall take instruction as to whether the corporation intends to utilize the lands mentioned in paragraph 1 of the petition in any manner or not. Then thereafter, this writ petition was finally heard and final order was passed. That is at page 88 and 89. Honorable Justice Das Adhikari heard this matter. And on the first page, at bottom, Mr. Ghosh, learned counsel, appearing for the municipal authorities, submits that the petitioner's property is not numbered and also not assessed. Since the municipality do not have any unassessed and unnumbered property in the area, no action could be taken by the municipal authorities. Heard the learned counsel for the respective parties and considered the materials available on record. It appears that the writ petitioners are claiming ownership in respect of the property in question, and nobody is claiming any title over and in respect of the property in question. Therefore, the municipal authorities are directed to accept the mutation application to be filed by the petitioners within a period of 4 weeks from date and to consider the disposal of the same in accordance with law, giving an opportunity. Thereafter, we filed the mutation application that has till not been disposed of by the KMC authorities. However, I am not coming before this court that my mutation has not been granted. My allegation is what has happened. Now KMC authorities has put up a signboard in the subject land. That is the para 13 of my pleadings. In utter shock when they found some personals of the KMC are putting up one signboard over the suit schedule property and claiming that the Rayati land of the petitioners belongs to them. All I am saying, without any acquisition, even previously there was a litigation and KMC was represented and KMC never claimed that this property had been acquired by the state or any other body and subsequently gifted to them or transferred in their favor. Still they are using my land as they are putting up signboard into my land. For not mutating my name, I'll go before the appropriate forum. Only in this case, I am asking that KMC should refrain their hands to utilize my land without any valid acquisition process.
Let us hear the KMC. Yes, Mr. Ghosh.
Illogically sees, my lord, that what I submitted before my lord, Mr. Ashok Kumar Das, yes, the lordship was in the municipal area, my lord, all properties are identified with the municipal premises number. They could not supply as yet, my lord, it's a municipal premises number. It appears, my lord, the municipal numbers was not allotted because the unassessed may be an unassessed property. That could not be identified where the property is. He is giving the DAG numbers and plot numbers, Mouja, all these things. I could not locate. Therefore, my lord, he is not interested about the mutation. The mutation application, he said, well, I have submitted. Then what is the result? Because in the previous interest, my lord, wanted that the names to be incorporated by mutation. Well, that was one round of allegations. What about the contentions pair are there? Was not accepted. Only the mutation part, the court said, they accept the application and decide the issue. Then possibly it could not be done because the property could not be identified. They are not interested. They have not pursued the issue, but that.
Call them for a hearing after that.
It could, unless it could be ascertained. I have not been ascertained this fact regarding the hearing and all the part. But I submit to today, as on this day, my lord, what is this case about? He is saying that till today he is in possession of the property. This is his statement.
By virtue of inheritance.
My lord?
By virtue of inheritance.
But whatever, my lord, possession is with him till today. But if the property is with him, my lord, he says that one occasion he found that somebody is putting up a signboard there. But the signboard, the question of acquisition and all these things that are there because he is saying that the property still today is in my possession.
Constructive position because he doesn't stay here probably.
No, he says my possession over the property which the corporation is trying to encroach.
Possession means constructive possession.
No, no, that means the constructive position, but he's saying as on this day in December when the it was affirmed, he's saying that corporation is trying to encroach as on this 20th December, 2022. Therefore, I have to ascertain, unless I could ascertain today, I also rang up to some of the authorities. They couldn't ascertain where is the property is. Therefore, if the property's location could be identified, then I can ascertain whether the corporation is in what way the corporation is in there or not. Then I may explore the possibilities once again, subject to my lord's assistance, my lord, that where the property is, then I could ascertain whether the corporation has entered in the premises, if so, when and how. Regarding mutation, all these things, I can ascertain only that in such a situation.
You did not give an opportunity to the petitioners to assist you.
Who will state the premises?
They should have been called for a hearing on the basis of the mutation application.
But now
That is
I
not
don't know, he is not saying regarding calling out about the mutation and all this, whether that is also to be ascertained, because I have not taken, frankly speaking, I have not taken that instructions, regarding that mutation part.
Since you're taking the same plea in this petition also, the petitioner can assist you.
But if the petitioner can identify and assist us, then I can look into it.
Call the petitioners for a hearing.
I'll do that, my lord. So far as the mutation part is concerned, I look into it. And they may call the petitioners, my lord, because the earlier petitioner, he says that they are the petitioners in interest. Now they are the successors, as I understand from my learned's contention. Then the successor may be intimated regarding the identification of the property, and then I can understand, my lord, what is the situation over there, whether the corporation has gone there or not, my lord.
Come back with the report.
Then your lordship, my lord, so far as yes, your lordship, my
Posted a signboard in the property. That means
the nature of the signboard also, my lord, he has not mentioned. He simply says the corporation has put up a signboard.
So what is the come to para 5 of my writ petition?
Identification number was given in.
So if property is unassessed, KMC can go and put up anything and utilize that land. Ownership is not required.
Mention the ward number as well. What number one?
Every details is mentioned.
No, the details of this property, I have seen it. The property, there is that number and all of the things. I do not, but very difficult for us to identify the location of the property on the basis of the DAG numbers and mojo number.
You want the premises number?
Yes, because
it's a seesaw.
They
won't assess, they won't mutate my name, they won't give the premises number, and on the other hand, they would say, sorry, I can't identify the land. So I will go ahead with the utilization of that land without having any title.
Please come back with the report, Mr. Ghosh. Municipality cannot go and occupy any and every land, isn't it?
No, that of course, that cannot, the corporation cannot occupy, but that sometimes, sometimes we find our property is being occupied by the private persons. Our property. Private property. We come, the legal proceedings goes on, the property is being handed over to by way of the, therefore, it is happening.
So if you want to take that stance, you can do that. That also you have not done. You have not claimed the property to be yours.
No, so far as this property, I'm
now
not
he is
talking about.
part. In the previous litigations, he never claimed.
I could not identify how could I claim. I claim by the claim may come, only I could identify.
For putting up advertisement, for putting up everything, KMC can identify the land. But whenever writ petitioner is
what
coming.
Department? What department? Let my learned say, what department has put up that signboard?
Without identifying, you have put a signboard.
Put up a signboard may be done by some of the department. But I must have to know as a lawyer if I am to take instructions from that particular department. I do not know there are several numbers of departments I have. Which department has gone there? I am to ascertain. Then I can ascertain.
On me to find out.
No, I cannot ascertain which department has done so.
Yes.
He says
that even we are not claiming that state has.
He says the pump house. I was rang up to the water supply department.
For the KMC seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading. Or
Your Lordship, direct us to submit a report, but I am not seeking because I don't know until Your Lordship, direct us to submit a
direction of the court.
Look at it. The petitioners claim to have acquired title and possession in respect of the plot in question by virtue of inheritance from their predecessor. Stop.
জাহাঙ্গীর দাস মনে হয় তাকে জাহাঙ্গীর তারপরে দাস
The petitioners approached the KMC for mutation of the property in their names, which is yet to be considered. Stop.
চলুন স্যার শুরু চলছে আপনি জান না আচ্ছা আমি যাই শুনুন ফার্স্ট হাফে মনে হয় না ফার্স্ট হাফে মনে হয় না হবে তারপরে হয় তো পরে আমি 5-এ যাবো 5-24 চলছে যাবো
In an earlier writ petition filed by the same petitioners?
Yes. Predecessor interest.
Filed by the
My mother.
predecessors in interest of the petitioners,
My mother and grandmother.
comma, a coordinate bench of this court, comma, by an order passed on 3rd June 2013.
24.
এখানে in an earlier writ petition বললেন না? ওখানে being numberটা বলে দিন তো। Being number 24944. 24944 within bracket W of 2007. A coordinate bench of this court, comma, by an order passed on
আমি
directed the municipal authorities
তুমি অর্ডার
to accept the mutation application to be filed by the petitioners therein and consider and dispose of the same within a stipulated time frame. Stop. The contention of the municipal authorities in the earlier writ petition was that the property of the petitioners was not numbered and also not assessed. Stop. Since the municipality did not have any unassessed and unnumbered property in the area, comma, no action could be taken by the municipal authorities. Stop.
আমাদের পজিশন কোথায় আছে তো
The said contention is reiterated by learned counsel for the KMC in the present writ petition also.
ওরাই তো মাত্রা ব্যবহার করে
Stop. Paragraph.
ওরাই মেরে আর করবো না ছেড়ে দেবো
আমি বুঝি
The petitioners allege that the KMC has put up a signboard in their property without any authority to do so. Stop. Paragraph, learned counsel for the paragraph, a letter report in the form of affidavit be called for from the KMC demonstrating whether the application for mutation submitted on behalf of the predecessors in interest of the petitioners has been considered by the authority in compliance with the order of this court, and also under what authority the signboard has been put up by the KMC in the plot in question. Paragraph, let the matter appear under the same heading on 6th September.
No, 1 month time be given, madam.
1 month, why?
Yes, madam. Because madam, I have to take instruction, madam, into tomorrow.
In 1 month, the plot can be assessed.
Kindly injunct them to
What is
further encroachment.
Further encroachment? Let us ascertain, madam, what is the position there?
Then at 15th September. 15th September, paragraph, the KMC is restrained from making any further encroachment upon the plot in question in the meantime.
Madam, I'm deeply honest.
Further encroachment, further encroachment, I do not know.
There's a signboard put up by you.
They say what the entire property has been encroached.
By next.
He's trying, his contention is trying to encroach. In the petition. Now, but in the body of the petition, he says that he's trying to encroach. The paragraph, specific paragraph was there.
Paragraph 13 says it has been put up.
Trying to encroach by putting up a sign.
No, Madam, these different paragraphs are there. I may link you, Lashwar.
Next. 1 PM. 1 PM.
Item 121 fixed at 1.
There's a
Malad,
special
I'm
fixed
for
matter at 1.
File Malad affidavit of service. Malad, petitioner Malad suffer a order of demolition and also Malad impugn notice of eviction Malad, page 45. Malad, what happened Malad? Malad, private respondent of this writ petition.
I appear for the answering number, respondent number 2, my lord. I'll demonstrate the case before lordship.
There are private respondents.
Yes, Malad, I have served.
National Highways Authority.
Yes,
Lord, I
served.
appear for the national highway authorities.
Private respondent
My
Malad received.
senior friend.
What about the private respondents?
Malad, they have received Malad. Delivery confirmed. Plus. Malad, what happened Malad? Private respondent earlier occasion move on writ petition. Malad, kindly see the Malad certified copy of the order. Malad, page 19. Page 19 Malad.
1919.
Yes, Malad, 19.
19 is the writ petition.
No, Malad.
The page 22, my lord, is the order dated 30th of
No,
February
Malad, I am
2020.
showing Malad cause title. Malad, this petitioner is the party in that writ petition. There is a Malad private respondent, Malad, kindly see. Private respondent is Malad Raju Tati, Prosenjit Tati, page 21. Bharati Tati and Vishwanath Tati. And Malad, this petitioner is the Malad Raghunath Tati. Malad, this order, private respondent move this that writ petition, their Malad ingress and egress is obstructed by the private respondent. And according to this order, Malad, kindly see Malad page 25. The executive engineer, National Highway Authority 1, passed an order, Malad, 29 March 23. Page Malad 25.
Yes.
Malad, kindly see Malad paragraph 5. After perusal of the demarcation of land made by BLRO Kulpi, it is clear that private respondents, namely Prosenjit Tati, Raju Tati, Raghunath Tati, Vishwanath Tati and Bharati Tati have occupied the national highway land by way of encroachment. Malad, this Malad Raghunath Tati described as a private respondent. Although Malad, he is not a party in the writ petition proceeding. So Malad, unless the Malad his name incorporated in the temper the order sheet or whatever may be, because of National Highway Authority, Malad, Executive Engineer Division 1, he is the Malad competent authority. How Malad described as a Raghunath Tati as a private respondent? So my prayer is that Malad, no order has been passed in the writ petition against this present writ petition. So how this Malad executive engineer passed an order that Malad Raghunath Tati is a private respondent?
May I demonstrate, my lord?
What
Then-
is the order in the writ petition?
Page 23, my lord, will kindly see second
Yes.
paragraph of the page 23.
Yes.
Lord, the appropriate
my lord.
authority was directed to remove the encroachment in
Whatever.
terms of the National Highways Act, my lord,
Yes.
within a span of 45 days.
Then Malad, I
Order
come
is
to
dated
not
30
my concluded Malad, this submission Malad. Malad, this order Malad, this demolition order has been passed Malad 29 March 2023. Malad, some of the private respondent they moved Malad appeal against the Malad that order. That order is Malad page
41.
page 41.
Yes. You are also one of the appellants?
No, Malad, I am not in that program, but I incorporated that this in connection with the same order. What happened Malad, this?
Page 31, you are the appellant.
No, no, the
No, Malad,
petitioner
page
is
31.
Raghunath Tati.
Malad, page
And-
31, Malad, what happened? Malad, this order, Malad, appeal has been preferred by the Raghunath Tati. Malad, Land and Traffic Act, Malad, appeal has been preferred. And
before the district magistrate. As my lord, private respondent file also contempt application. In the contempt proceeding, the learned judge directed that justice that prefer appeal before the district magistrate as a land and traffic act. So my lord, appeal has been preferred, page 30, by this Raghunath Tati. He described that I am not a party in the that related proceeding. So I am that order is not binding upon me, that appeal before the district magistrate. Now, my lord, the appeal, mandamus appeal preferred by the some of the private respondent of this writ petition. That order, my lord, is start from page 40. And my lord, kindly see, my lord, page operative part is, my lord, page 42.
Yes.
On the last portion, after the order dictated, the learned council of the state submitted that appeal before the district magistrate filed by the appellant is not maintainable. He is not the competent authority. If that be so, district magistrate shall either return the memorandum of appeal to the appellant or forward the same the appropriate authority with intimation to the appellant. Or who has the private respondent of that writ petition, they preferred mandamus appeal, that order has been passed. Now, my lord, I am showing another order, my lord, contempt proceeding in the that writ petition, what order has been passed. My lord, page 43, contempt has been dropped. My lord, page 43, my lord, kindly see. 21st April 2023. Page, my lord, 43.
Because page 41 has nothing to do with you, your case.
Page 41.
Some other private respondents.
Yes,
this
my
has
lord.
nothing to do with the present.
Yes. Then, my lord, that, my lord, writ petition, my lord, contempt proceeding, final order has been passed, my lord, 21st April 2023. Page 43. The paragraph 3, my lord, remedy of appeal under the Consent Act has been allowed to be availed by the private respondent. And private respondent may therefore avail the remedies as directed by the division bench, order dated, my lord, 5th April 2023. So, my lord, remedy before the appeal. Now, my lord, paragraph 4, page 44. Alleged contemptor shall take steps as required under the statute subject to any order that may be passed by the appellate authority. And my lord, contempt application is dropped off. My lord, now, my lord, according to my lord, division bench order, my lord, appeal preferred before the district magistrate. District magistrate not return, not send the appropriate authority. My lord, what happened, my lord? Till date, my lord, National Highway Authority at the district magistrate not in a position to told the who is the appellate authority, where is, my lord, tribunal is functioning. That they not informed till date. And my lord, this writ petitioner, my lord, they are not a party in that proceeding. That order is not binding, and that proceeding he has a described as a private respondent, and my demolition order has been passed.
Challenge that order.
Yes, that order, that order, my lord, challenge in this writ petition, and also, my lord, appeal preferred by the district magistrate.
Have you preferred an appeal?
Yes, my lord. Yes.
So that is when.
Page 30.
That is
Page
written, my lord.
30.
My lord, I had submitted before the Honorable Division Bench. Initially,
Not
my
returned.
lord, I failed to assist
Not
the
returned.
Honorable Single. But I failed to assist the Honorable Single Bench that the tribunal is the appellate authority and not the district magistrate in terms of the act. But I could, however, my lord, assist the Honorable Division Bench, and the Division Bench was kind enough that to hold, my lord, that if the district magistrate is of the opinion, my lord, that he is not the competent authority, my lord, he shall return back the appeal to the petitioner. My lord, will find by my lord, the letter dated 12th of my lord, April 2022, 23, my lord, the district magistrate has written to the petitioner that he is not the appellate authority, and the petitioner is free to my lord, approach the appellate authority if he so desires. Thereafter, my lord, time and again, difficulty is, my lord, I find no pleasure in throwing him out. But there is an order staring at my eyes since 30th April, my lord, 30th November 2021, which says, my lord, directions was issued, my lord, will find at page 23, my lord. In view of the matter, the Diamond Harbour National Highway Division shall forthwith cause an inquiry into the constructions made by the private respondents, more fully described in the annexure P5 and P7 to the writ petition. In the event the National Highway authorities find that the construction made by the private respondent is on the land belonging to them,
urgent steps shall be taken to demolish the said construction and possession of the said land shall be taken. But his grievance, as ventilated.
This
Sir, I have not
this
interrupted.
petitioner
I
is
have
not a private
interrupted you, sir.
respondent.
Please allow me.
He is not a private respondent. Yes, ma'am. Sorry, ma'am.
My lord, his grievance in the entire writ petition, not a sentence. He says that I am the lawful owner of that plot of land. What he ventilates is the writ petition was filed alleging the encroachment by the private respondents. And I was not a private respondent therein. Why did you proceed against me? My lord, while the inquiry was meant by the concerned BLRO, my lord, the BLRO discovered not only the private respondent, the petitioner, before the earlier writ proceedings, my lord, Dinonath Mondor, my lord. In this earlier writ proceedings, my lord, the petitioner has made encroachment and the present petitioner has made encroachment. So, my lord, he directed order of removal, which is at page 25.
The petitioner has preferred an appeal against this order at page 25.
Yes, my lord, the
Yes.
petitioner has
Page
preferred
30.
an appeal.
30.
The
And
tribunal.
before the, my lord, that, my lord, time and again, we have requested the counsel of the petitioner to inform whether they have preferred an appeal before the tribunal. My lord, as on date, we have not informed anything.
My lord, kindly see, my lord, page 37.
My lord, will kindly take this document where the
Kindly-
district magistrate has returned his.
My lord, kindly see, my lord, page
appeal, my
37.
lord.
Page 37, my lord.
Give me a minute.
My lord, I have, this petitioner wrote a letter to the executive engineer and district magistrate. Where is the address of the tribunal so he can file appeal? My lord, kindly see page 37 of the writ petition. Page 37 of the writ petition, my lord. 13 April, my lord, 2023. Therefore, supply the address of the National Highway Tribunal under the control of National Highway Traffic situated at Kolkata or West Bengal, my lord. 13 April, that has
It
been, my
is
lord,
not
sent.
for me to, my lord.
My lord, he is the, my lord, authority. He is,
I
my
am
lord,
not the
demolishing.
authority.
My
That's
lord,
what I said.
National Highway Authority is the executive engineer passing dismissal order. Who is the appellate authority? Where is the, my lord, tribunal? He is not in a position to say. That is, my lord, true, my lord. My lord, whatever may be, my lord, trespasser have a right. My lord, nobody, my lord, wrongfully be.
Search of the
Yes.
appropriate forum. Can you
Yes.
help him with that?
Yes.
My lord, today, my lord, I believe.
A statutory appeal.
But today it is also time barred, my lord.
My time.
My lord, may be permitted.
Yes,
My lord, the appeal court's order is there, my lord, to return back the,
yes,
that is
yes.
the last portion.
And it
my
has
lord,
been returned.
To return back.
It
Not
has been
written, my lord.
returned.
My lord, not written, my lord. Original appeal copy is lying, my lord, with the district magistrate.
But he
Or not
admitted,
written, my lord. My submission is not written.
It is, it is. তুমি তো এতক্ষণ বললে, কি বলেছি? My lord, page 37.
Yes.
In that, my lord, that is not the proof of that he received the same money. That my learned friend which handed over to you, to your lordship, that is not the, he received the same, my lord.
No,
That
no,
is not
page
there.
38 below.
দাঁড়াও ভাই, তুমি তো অনেকক্ষণ বলেছো।
Page 38 mail through.
My lord, 37. My lord, 1, 2, 3, 4. Fifth line, my lord. I have filed appeal before the district magistrate South Chowdhury. But the district magistrate has intimated through my advocate on record that he returned the appeal. That is the appellate court order to return the appeal if you have not any jurisdiction. That is admitted that he returned the appeal. We have
But-
intimated to the to his advocate that we returned the appeal and
But
sent
hard,
the
hard,
same
hard,
appeal.
but hard,
That- that
hard
is my
copy of
lord-
the appeal has not
That
been.
is, my lord, we have completed that thing, my lord. Now it is his part, whether he will file appeal or that appeal will be filed where,
Where?
that is his
No, no,
part.
Mr. Dey, he wants to file an appeal. He doesn't know which tribunal to file the appeal.
My lord, it is not my headache. I have complied the order of the appellate authority, my lord. That is appeal court that directed me, if we have not any jurisdiction, return back the same. We return back the same.
The
Now
state
it is
will not
returned.
help you, sir, I am afraid. You have to find out which tribunal you have to prefer.
National Highway Authority also will not help. He is my lord, demolishing order. He don't know who is the appellate authority, whose order.
We can.
Well,
attempt
if
for
my lord,
that,
if
my
my
lord,
lord, there
but
is
today,
no
my lord,
appellate
my
authority,
lord,
then
will
your
kindly
lordship
see the
must know.
conduct. We have returned the appeal on 12th of April, if I'm not wrong, my lord. Tomorrow is the demolition. At the last moment, he's coming and installing with an attempt to stall everything, my lord.
No, no,
This is not done, my lord.
no.
As on
April, you have returned this. 13th April, he has written to the state.
true, my lord,
The
but
state has not cared to give a response to the effect that we are not responsible. The
My
state
lord,
could have
the
given a
state-
negative
that is
response.
the national highway, my lord, actually.
The state-
National highway,
So
this
you
is
could
not
have
a state
informed
matter.
the petitioner.
That is not the state's matter, my lord.
No, no,
That is
have
the,
you informed that to the petitioner that this is not the state's matter?
yes, my lord, what
Very
that is,
good,
we
very
return
good.
back. What that is, my lord, we return back the
After
same.
returning back this, and
On 12th, my lord, we return back that.
And on
And
13th,
on
13th,
13th, my lord, he admitted that he written a letter to the district magistrate. and
Requested to
executive.
supply the address of the tribunal.
on 12th, you return back.
Yes, my lord.
On 13th, they have written a letter to you asking your help, asking for your help.
My lord, district magistrate, I am not the central government officer.
So have you written this back to the petitioner that since I'm not the central government authority?
Yes, my lord, that
I
was,
cannot help you.
yes, my lord.
No,
You have not
no.
replied to this letter.
Yes, my
we
lord.
have not repeated ourselves, my lord. It can be, my lord, will kindly say,
That's
look
also
at.
part of the petitioner. Since 13th April, he has been waiting for your reply and you have not bothered to
My lord,
reply.
we have not repeated ourselves. We have said, my lord, we are not the competent authority and it is for
He has asked for an assistance from you, sir. If you would not have, if you could not provide him with that assistance, you could have stated at least that we do not know, we cannot help you. That is not done. Immediately, he has written a letter to you, asking for help. As to be for which tribunal he can prefer the appeal. No reply was there. You could have given a negative reply at least. That was not done.
Today,
So the
my lord,
demolition order will be stayed. I'll give liberty to the petitioner to prefer an appeal
Yes.
within 7 days.
Yes.
Yes.
my lord will,
Again, before which forum?
Well, I don't know, my lord. My lord, if my lord appeal is not functioning, my lord, your lordship, stay the matter for limited period and heard the matter. My lord, main dispute is, my lord,
Disposal of the appeal.
yes, my lord.
But then where do you prefer the appeal?
Then, my lord,
my lord will kindly.
then, my lord, I
kindly
went
not
to
do
the,
that,
my lord, Delhi, my
will
lord,
kindly
send
consider
the central government, my lord, who is the appellate authority.
competent authority doesn't grant a stay, my lord. My lord will kindly not stay the order till the disposal of the appeal.
Who is the
To be,
competent
to
authority
be
grant
filed by,
this?
my lord, tribunal is the authority. That's what we find from this
If
statute.
the tribunal takes up the matter, a stay will continue.
Yes.
So, my lord, he may not file an appeal within 7 days.
If he doesn't, the order will be automatically vacated. I'll give him some time to prefer an appeal because it's your lapse.
No, my lord will kindly, subject to my lord's kind, if my lord, this is feasible to the honorable court, my lord, with all humbleness, I say, my lord will give him a breathing time within which he can file an appeal.
Yes.
But then again, my lord will thereafter, once he files an appeal, my lord will kindly note that the appellate authority will not be, my lord, influenced by my lord's order first, my lord. Secondly, my lord will note that if there is no order from the appellate authority, if the petitioner is not able to show a stay order to the respondents within whatever span your lordship desires, my lord, the respondent shall be at liberty to carry on the, my lord,
That's true.
execution.
And even if the appeal is not filed within the stipulated time period.
My lord,
the
your
order will
lordship
be
dispose
vacated.
of
That be your lordship.
That's
Sir,
our standard.
sir,
My lord, your
certainly, my lord can.
matter directly give to file appeal within 50
I will
days.
do that. I will
And
do that.
till such disposal of appeal, that
Till filing, my lord, my lord will.
My lord,
Till disposal.
my lord, some
my
time
lord,
will
that
be
is the-
taken, my lord, because, my lord,
Disposal-
petitioner, my lord, will find, my lord, who is the appellate authority.
It's taken up
Yes.
for hearing by the.
Yes.
No, my lord, we know, we see writ petition, my lord will
That is
kindly look at this, my lord. We have experience, well, writ petitions of 2019.
The tribunal may not take up the matter for 10 days or a month.
My lord may indicate that
The matter is taken up for hearing. the-
years will go, my lord, we will not be in a position to execute the honorable order of this honorable court, my lord. My lord will consider the honorable division bench did not protect the interest of the petitioner to that
But
extent.
holding that remedy of appeal.
Well, the honorable division bench did not protect the interest of any of the petitioner to that extent. Well, your lordship can
But remedy
certainly,
is appeal.
my lord can,
Observe.
The order of the honorable division bench is absolutely something else. There was no scope for the division bench. to
my lord,
protect any-
even the persons who have moved the honorable division bench, they were not protected to that extent. The division bench was pleased to hold. My lord will kindly see the observations of the division bench, which is at page 42. After the order was, my lord, Therefore, at the top, my lord, therefore, the only remedy available to the appellant is, my lord, appellant today, my lord, he stands in the same boat. I'll accept that, my lord. My lord, the only remedy available to the appellant is to challenge the correctness of the order passed by the executive engineer, such and such, dated 29th, which he is also challenging, my lord, or any other that would have been passed thereafter. But, my lord, the honorable division bench even did not protect the
No,
petition.
with liberty, my lord. Next paragraph, liberty.
My lord, that is what I am stating, my lord. My lord will kindly give them, the appeal may be kept pending purposefully for years.
And my lord, my submission is, my lord, recorded that, my lord, National Highway Authority also not in a position to say the, my lord, who is the appellate authority, where is the tribunal. That must be recorded.
The ball is in
Then,
your
my lord,
court,
then, my lord, find out, but my lord, recorded their
Off the
submission.
record,
that-
my lord, I'll try
record
to
their
assist you.
submission. Record their submission that they also not in a position to.
Get
Yes,
copies
yes,
for the parties.
yes.
It is contended on behalf of the
বলে দিন আরেকটা
petitioner
matter আছে।
that in an earlier writ petition, being WPA number 2249 of 2021,
File করে দিন।
wherein the petitioner was not impeded as a party, comma, a coordinate bench of this court, comma, by an order passed on 30th November 2021, comma, directed the Diamond Harbour National Highway Division to cause an inquiry into the construction made by the private respondents therein, and in the event construction made by the private respondents was found to be on the land belonging to the National Highways authorities, comma, urgent steps were directed to be taken for demolition of such construction and resumption of possession by the authority. Stop. Pursuant to the said order, comma, the executive engineer, comma, NH division hyphen Roman 1, comma, by an order passed on 29th March 2023, comma, recorded that upon perusal of the demarcation of land made by the Block Land and Land Reforms Officer, comma, Kulpi, it appeared that the private respondents, including the present petitioner, occupied the National Highways land by way of encroachment. Stop. The name of this petitioner was included in the said order, despite the fact that the petitioner was not a party to the writ petition in compliance with which the order was passed. Stop. The petitioner preferred an appeal against the said order before the District Magistrate South 24 Parganas, stop, by a letter issued on 12th April 2023, comma, the district magistrate informed the petitioner, the district magistrate returned the appeal to the petitioner, since the said authority is not the appellate authority under the control of National Highways, the capital, the control of National Highways within bracket Land and Traffic, bracket closed, Act, comma, 2002. Stop. Immediately thereafter, comma, the petitioner wrote to the
Page 37 only. 13 April.
district magistrate and the executive engineer, comma, National Highways Division Roman 1, requesting them to provide the address / authority of the National Highways.
No, there is no
Tribunal
receipt to this letter, madam.
Page
situated-
38.
I have
Page
said
38.
wrote to,
Page 38 mail.
situated in Kolkata, in order to enable him to prefer the appeal before the said authority. Paragraph, the petition, no. In the meantime, put a stop at paragraph, the same paragraph. change. In the meantime, comma, the executive engineer, comma, National Highway Division Roman 1 has issued a letter to the Superintendent of Police, comma, Sundarban Police District, comma, Kagdip, comma, 24 Parganas South, on 10th August 2023, requesting police assistance for removal of the encroachment in terms of the order of this court. Stop. Paragraph, the petitioner seeks to prefer an appeal against the order passed by the executive engineer on 29th March 2023 and prays for stay of the letter issued on 10th August 2023 till disposal of the appeal. Paragraph. It is submitted on behalf of the respondents, comma, both the state and the national highways, that you are not aware as to who is the appellate.
No, no, I am appealing for the district magistrate, my lord.
You are appealing for the district
District
magistrate.
magistrate, my lord.
You said national highways.
No, 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 I am also, my lord, when your lordship inquire about national level, so my
I'll say just respondents.
respondent.
It is submitted on, it is submitted on behalf of the respondents that they are not aware regarding the appropriate authority who can deal with the appeal intended to be preferred by the petitioner. Paragraph. In view of the above,
My lord,
this court
kindly-
is inclined to hold that the petitioner be granted liberty to prefer statutory appeal against the order dated 29th March 2023 within a stipulated time frame comma, in the interest of justice. Paragraph, the writ petition is accordingly disposed of with liberty to the petitioner to prefer an appeal before the appropriate forum against the order dated 29th March 2023 passed by the executive engineer, comma, NH Division Roman 1 in accordance with law. Stop. In the event the petitioner prefers the statutory appeal within 15 days,
Yes, ma'am.
within 15 days from date, comma, the appellate authority shall deal with the appeal on merits without dismissing the same on the ground of limitation. Paragraph, the
That will dispose of within certain timeline.
the appeal,
Yes, madam.
No.
paragraph, it is expected that the appellate authority shall dispose of the appeal
Well, statute, my lord, shows that, my lord, within 4 months.
Yes,
Statute shows, my lord, if appeal filed before the tribunal, that will be disposed of within 4 months.
Your lordship can, whatever.
3 months.
My lord.
Within 3 months from the date of filing thereof, upon affording reasonable opportunity of hearing to all the interested, to the parties, to the parties therein, comma, in accordance with law. Paragraph, the order dated 29th March 2023 and the letter issued on 10th August 2023 be 23 insofar as the petitioner is concerned, be stayed till the appeal is taken up for hearing. Paragraph, in the event the petitioner fails to prefer the appeal within a period of 15 days from date, comma, the order of stay shall stand automatically vacated.
Lord, my lord will kindly observe that the appellate forum will, my lord, decide the fate of the appeal without being governed by my lord's observation.
Stated anything on merits.
My lord, in spite of that, my lord, unless this observation is there, my lord, we have seen, my lord, the Taiwans are extremely scared, my lord.
It is made clear that this court has not gone into the merits of the case, and the appellate forum shall be at liberty to deal with the appeal independently, deal with the appeal on merits independently, without being influenced by any observation which may have been made in this order.
So very good. Lord, we are extremely, my lord, sorry to hold your lordship during tiffin hours, my lord.
My lord, other,
I wanted to actually.
Well, this was urgent, my lord.
my lord,
This
other
needed
repetition,
my
my lord,
lord's- Absolutely.
my lord, other repetition,
Forget also by the.
my lord, my lord, may I
As
sub-
your lordship will never.
Yes.
my lord, other repetition, my lord, similar issue, my lord, same proceeding, that, my lord, repetition I filed.
Mentioning time, sir,
No,
I'm
my lord.
sorry.
That was filed, my lord. It was similar order will. Yes, yes, get.
So by 120. 120.
Well, I beg to lodge.
Well, I am appearing, my lord.
I am appearing for the private.
I am appearing on behalf of the petitioner.
I am appearing, my lord.
Yes. Yes, what is the matter?
Yes. Well, actually, I am operating on interstate roads. On page number 32.
এটা একটা নাম্বার নেওয়া ছিল বলে নিয়েছি আমার ফাইলের সঙ্গে
Page number 32. I obtained a permanent stage case permit on interstate road.
Mr. Bhattacharya for the private respondent?
Yes, private respondent 7. Yes. Page number 32. Well, initially the permit was issued serial number 8. Now dear to Tata. Thereafter, my lord, later on, I made an application for curtailment of the road from Naudi to Fusru and extended up to Gumia. From Fusru, my lord, at the bottom left side. After curtailment extension, my route is now Gumia to Tata. Page number 34 is a timetable after extension and curtailment.
Yes, Gumia to Tata.
Timetable, my lord, has issued from Gumia to Tata.
Yes.
My departure timetable 140 at Tata Point. And another, I am obtaining another permit on interstate road, page number 35. The route is Durgapur to Jamshedpur. And timetable all from departure timetable from Jamshedpur 135. And page number 37 and 38. Both timetable has been countersigned by the state of Jharkhand because route is covered by 2 states. Page number 37 and 38. Well, my grievance against the private respondent number 7, page number 39. The Bharat Chandra Sharma, he obtained the permit from the state of Jharkhand from Bokaro to Chaivasa. And the middle portion timetable has been mentioned, that is departure timetable from Tata for down point, that is 3:30 p.m. And my vehicle, 130, 140 and 135. So there's a 2 hours gap, there's no problem. And since this permit was issued in the year 1986, since 1986, this timetable was vehicle was operating on the basis of this timetable, so there is no problem. Now, my lord, after expiry of the permit, because permit was on continuous process, permit was renewed, and the permit was valid till at the time of renewal, page number 44. On 20 September 2021, a notice was issued because petitioner, before renewal of permit, petitioner, respondent number 7 submitted a proposed timetable by changing the timetable. And in Hindi version, that the state of Jharkhand issued a notice inviting objection from any other operators if there is any objection on this timetable. So that objection may be accepted by the authority within 7 days. Time limit has been fixed. And kindly come back, page number 40.
Yes.
I made an objection on 24th September 21.
Yes.
Long prior to 7 days, because within 3 days, my lord, I raised the objection before the state of Jharkhand from the petitioner to Joint Transport Commissioner, Government of Jharkhand. And my lord, in this objection, I said so many things, but main objection was that is, if this proposed time to be accepted, only 5 minutes gap or 10 minutes gap in my vehicle, that is very difficult to fly the vehicle. And I also submitted one copy, objection of the one copy to the state of West Bengal, page number 65. State of West Bengal. same copy was submitted. Now can you see the 68, page number 68. Without consideration of my objection, the state of Jharkhand, the permit was renewed in favor of the private respondent, along with the proposed timetable, page number 70, without considering my objection, which was proposed, that has been accepted. Page number 70, this proposed timetable was extended, was issued for 2 months. And next page, page number 71, because permit will not be valid to the other unless the permit is countersigned, also timetable is countersigned. So STH, Secretary STH Jharkhand requested the Secretary STH Transport Authority invite memo dated 12 January 2022 to countersign the permit as well as countersign the permit timetable. And before countersignature, the state Secretary ST West Bengal informed the petitioner to consider the objection, because one copy was submitted before the ST Jharkhand. Now can see the page number 74. This notice was issued 7 June 2022, page number 74. And I've been asked to appear on 21st June 2022. And decision was taken, page number 87, that was communicated, page number 87, page number 87, that my application was rejected on the ground that my submission has been recorded also. And middle portion, after my lord, the objector lost objection on 29 September 2021, when there was no scope of renewal for counter signature of the objective permit. The objective permit was renewed later on 12 January 2022, and permit holder applied for counter signature on 16 February 2022. The objective vehicle was not flying as the permit was not countersigned. Moreover, it has been observed that 5 minutes time gap is not significant nowadays when permits are being issued in liberalized policy. Well, I've raised the objection that is the since last 5 years, our private respondent was not flying the vehicle, and but their decision was taking as the permit was not countersigned. But I have not given the objection on the new after renewal of the permit. However, my lord, so far the timetable is concerned only 5 minutes. There is no significant because interstate road, only 5 or 6 vehicles are flying on this road. No, my lord, I have also met. So I have challenged this, my lord, decision on two false grounds that I made an objection that in gap of my lord 5 minutes gap, but it is not possible to fly the vehicle because private respondent departure timetable at Tata Point 1:30. My departure time after 5 minutes or 10 minutes. So there is no. It is impossible to fly the vehicle on viable portion. So my lord. Then also I have one document has been annexed, page number 88. The private respondents will obtain another permit on the route Bokaro Steel City to Purulia, and the vehicle number, page number 12, registration mark 1390. This permit has issued against this vehicle number.
Yes.
But the petitioner flight the vehicle while displaying this vehicle, page number 101. I have given the photograph displaying this vehicle number and also displaying the vehicle front side, Bokaro to Chaibasha, because his vehicle number, my lord, often the permit. Kindly come back. Page number 68, serial number 12, is registration mark 3651 vehicle number.
Yes.
Why this vehicle was flying on this route? Because this vehicle, my lord, fitness certificate expired. So, but that time of the vehicle, my lord, cannot ply the vehicle because this vehicle is endorsed in this permit. And my lord, Bokaro to Purulia, vehicle number 1390, this vehicle will ply on this road only. But he's plying the vehicle, displaying this vehicle number, that this vehicle is plying also on another route. Route only by Chairas to Bokaro. Well, I made the objection. Now, my lord, last objection, my lord, I have made the representation, page number 106. Page number 106, 106, last 106.
Yes.
Because my problem actually regarding the issue of timetable. My lord, subject requesting a proposed revised timetable for Mr. Bhattacharya in order to avoid classing of timetable. So I am alone. I'm placing this person with the reference to the aforesaid. I Om Prakash Gupta, an ailing and bona fide operator on the road of Naudia to Tata, and the same extends up to Gumia via Pusto, Jonaimo, Chas, Bokaro, and Purulia. Be it mentioned that my vehicle bearing registration number such and such, the permit has been plying on the road with a valid interstate road permit duly issued by ST West Bengal, and also bears the counter signature of ST Jharkhand in terms of interstate reciprocal transport agreement. Beg to state that the following also basis your kind notice here and there. That Mr. Bharat Chandra Sharma, being owner of vehicle bearing the registration number such and permit number such had an old timetable departure from Tata to Bokaro at 3:30 p.m. But all on a sudden, Mr. Bharat Chandra Sharma had changed his aforesaid timetable. The revised timetable is 5-10 minutes prior to my vehicle in the aforesaid road. Some of the vehicles which are flying from Tata to Bokaro along with their time departure from Tata are mentioned thereunder. These 5 vehicles are flying from in between Tata to Bokaro or Purulia. First vehicle was start in the name of Ma Parvati, 11:40 a.m. And next vehicle, 12:15. That means here also that is 45 minutes gap. Here also next another vehicle, departure time at Tata 1:05. They are also at least 50 minutes gap. And Bharat Chandra Sharma, they are after 1:30. Here also 25 minutes gap. My time to only 10 minutes, one vehicle, but another vehicle I am not given here. And next vehicle, my lord, there are 1 hour, 50 minutes gap. Now, my lord, on perusal of the aforesaid timetable, it would be palpable that all the vehicles excepting mine have a gap of at least 25-50 minutes gap. Be it also mentioned that previously I had a gap of 30 minutes, but soon after Mr. Sharma had revised his timetable, my timetable has reduced to 10 minutes, which has drastically affected my business, as also I had to face severe financial loss. The common distance between my route and the Mr. Sharma's route is approximately about 145 kilometers. In accordance to the reciprocal transport agreement, the state of West Bengal and Jharkhand 2004, the number of quotas allotted to Jharkhand is more than those of the state of West Bengal. For example, 5:1 ratio, 4:2 ratio, 6:3 ratio, etc. From the aforesaid, it is given that if timetables are not revised to people, that Mr. Sharma's, then the same would cause great damage to the bus owners of West Bengal in the long run. In such circumstances, it is my humble request to your good office to kindly look into the aforesaid matter and further be pleased to propose a different timetable, for example, 12:45 p.m., 1:20 p.m., 1:55 p.m. for Mr. Sharma, so that none of us are affected in any manner whatsoever. So I made the representation. Along with the proposed timetable, that I have annexed, but later on, after filing this petition, I have submitted another proposed timetable that is also pending before the authority. So kindly date the Director Authority Secretary State Transport Authority to consider the representation after hearing both parties.
Yes. Are also interested parties.
So what is it?
Yes. First of all, we are not here to resolve the dispute relating to timetable. There is a domain within section rule 119 of the West Bengal Motor Vehicles, where the decisions of the secretary is the final. But the secretary has already taken a decision. That decision has been challenged in this petition. Simultaneously, a separate representation is being made. And let it be considered.
Thank you. Because we are come to settle the issue.
But my lord, so far the
Otherwise,
allegation,
this battle will never be end.
allegation regarding the illegal ply, that has been, my lord,
Allegation regarding
the illegal ply.
no, no, that is not the issue.
That is not the issue here.
That is not the issue.
That is not the issue here. Here
That is not
only,
the
my lord, page 106, let it be considered by the Secretary STA within certain time after giving hearing to all the stakeholders and
6 weeks.
6 weeks. My lord, my lord.
Third learned counsels for the parties.
This more three.
Respondent number 3, that is the HT.
Secretary STA.
Secretary STA, Secretary STA.
The petitioner and the private respondent are stage carriage permit holders yes, in different routes. Stop. The grievance of the petitioner is that the private respondent was flying his vehicle on the basis of an old timetable wherein the departure time from Tata to Bokaro was 3:30 p.m. Stop. A revised timetable was issued in favor of the private respondent, wherein his departure time from Tata was 10 minutes or 5 minutes.
10 minutes.
10 minutes.
10 minutes. 10 minutes and 5 minutes.
5-10 minutes prior to the departure time of the vehicle of the petitioner. The other vehicles, some of the other vehicles flying from Tata to Bokaro have a gap of at least 25-50 minutes.
But which is objected to?
Yes,
Which is objected to?
this is the contention of the petition. 50 minutes. From Tata. So, according to the petitioner, the reduction of the time span of departure of the vehicles of the petitioner and the private respondent has affected the petitioner's business severely. The petitioner submitted a representation before the concerned authority on 14th June 2023 seeking revision of the timetable of the private respondent so that both the petitioner and the private respondent can ply their respective vehicles in the said route without any disturbance. Stop. The representation is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph: upon consideration of the submission made on behalf of the parties, comma, the writ petition is disposed of, directing the third respondent,
Third respondent, my lord.
third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
After giving opportunity hearing both parties.
Yes, yes.
Yes.
All interested persons, including both. Dispose of it.
Deeply obliged, my lord.
My lord, the allegations made in the petitions. Your lordship kindly have.
The usual line, yes. Since no affidavit, land shall have.
Deeply obliged.
Vehicles without any disturbance.
My lord, private respondents may be allowed to submit the necessary documents at the time of hearing.
The parties,
The activity always there.
Always, always.
একটা লাইন অ্যাড করুন এখানে ডিসিশন টেকেন বাই দ্য অথরিটি বললাম তার আগে the parties are at liberty to produce relevant documents before the authority at the time of hearing.
Deeply obliged.
তারপরে the decision taken by the
My lord. My lord.
123.
For the petitioner.
Yes.
Affidavit of service. My lord, the petitioner is a permanent contract carriage permit holder, my lord, in respect of an auto rickshaw, my lord. The permit was issued by the Regional Transport Authority, North 24 Parganas, my lord, in the year 2005. And thereafter, the permit was renewed up to 2015, my lord. The permit is at page 20. Lordship kindly come to page annexure P1. This is the permit. Initially, the permit was granted. It was valid up to page 20. Lordship.
Yes.
It was valid up to 17th March 2010, my lord. The number is at the top, my lord, PCOP 6250/BS. And thereafter, my lord, the number was changed. The new number was given, that is at page 23, annexure P2.
On renewal.
On renewal, the permit number was changed, my lord, 6250/A/N. And thereafter, this permit was valid up to 17th March 2015, my lord. And thereafter, he made an application for renewal of his permit. And he has also made an application for replacement of his old vehicle by a new model of vehicle, my lord. He has purchased the same. I have annexed the registration certificate, that is at page 25, my lord. The representation he made, that is at page 35, my lord, annexure P7. He made the representation with the Regional Transport Authority, North 24 Parganas, that is on May 4 to 2023, my lord. That has to be considered by the authority. This is my innocuous prayer. Let the prayer for renewal of permit along with the replacement of vehicle be considered by the authority in accordance with law.
Yes, Mr. Dey.
Yes, ma'am. By the respondent number 2.
6 weeks.
Yes.
Affidavit of service. The petitioner was granted permanent contract carriage permit for his vehicle being number WB23A, vehicle bracket auto rickshaw. WB23A/7447 in an intra-regional route. Intra, intra-regional route from Shamnagar to Kakinada. Stop. The permit was initially issued on 21st March 2005
Yes.
and was valid for a period of 5 years. Stop. It was subsequently renewed
Up to 17th March 2015, madam.
for a period of 5 years and was valid up to 17th March 2015. Stop. The petitioner submitted an application before the concerned authority on 4th May 2023 seeking renewal of his permit. Stop. The petitioner also intends to replace his vehicle which is of old model, by a single mode MODE, single mode LPG auto rickshaw bearing registration number WB25D/7670 of the year 2011 and submitted documents in this regard along with the application filed before the authority. Stop. The said application is yet to be considered.
Yes.
Stop. The petitioner prays for a direction upon the concerned authority to consider the application at the earliest. Paragraph. It is submitted on behalf of the respondents that the second respondent be directed to consider the application with the representation application in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the second respondent to consider and dispose of the application submitted by the petitioner dated such and such within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof.
Yes.
Disposed of which action? Next.
124.
I appear for the petitioner. That is my service.
And for the state. Take the microphone.
But I have filed the evidence service. The respondent number 6, respondent
Please
number
appealing for respondent number 6.
on the respondent number 6 on the yesterday I submitted to the lordship. So for the respondent number 5 is concerned, it has been returned refused.
And 6.
And 6 unknown. So for the 6 is concerned, I made a prayer before the lordship to expunge the name of the respondent number 6. Against whom I have no grievance at the present moment. Therefore, my lord, respondent number 5, it has been refused. Therefore, it needed to be good service.
Yes.
But I made specific objection with the authorities at page 19. Page 19, the annexure P3. I made specific allegation that one permit is covered under 2 permit. One vehicle is covered under 2 permit at a time, which is not permissible under the MB Act and the rules. Therefore, my said objection is directed to be considered by the authorities upon affording opportunity of hearing to the parties concerned. That's page 19, Lord. I have annexed the copy of the permit also, which reflects that one vehicle is covered under 2 permits at a time.
2 routes, 2 separate routes, 2 permits.
One vehicle is covered.
2 separate routes, 2 permits.
Yes, 2 permits, which is not permissible as per rule 147 of the Bengal Motor Vehicles rules. Therefore, my prayer is to be decided by the authorities upon affording opportunity of hearing for taking appropriate steps to cancel one permit. That law says so. If one vehicle is covered at 2 permits at a time, then 1 permit has to be cancelled. Let the authorities take appropriate steps upon
Yes.
affording opportunity of hearing to the parties concerned.
This is the instruction. What does your instruction say?
If the record says that 1 permit has been surrendered, then 1 permit should be retained by the vehicle. It has to be verified by the authorities.
One of the numbers is WB 41J. Permit
This
number is
valid of
11 by 1991.
2023.
But the allegation regarding the vehicle number, Lord, WB 41J 2035.
Yes.
It reflects from the records that this particular vehicle is covered at 2 permits at a time.
But 203, but here 2 different vehicle numbers are there.
2035, page 19, Lord, page 19.
No, have you seen the report? Two zero three five is under permit number 6 of 8788.
But the present registration number is under the permit number so and so. The previous bus registration number permit was 2035. The said permit is valid up to 223.
A second is PSD.
And this vehicle 2035, it reflects from the documents at page 19 and 20 that it covers 2 permits at a time. I have annexed the copy of the permit. But let the authorities be directed to verify the records and take an appropriate decision upon affording opportunity of hearing to the parties concerned.
Because the report is contradictory. It doesn't really, what is the
But
meaning?
it is
I
not
cannot
clear.
tell
It is
what
not
the
clear
report
from
says.
it is not clear from the
Let
report.
the representation be considered, don't give
Yes.
your report because this is contradictory.
Yes. But the respondent number, the respondent number 3 may be directed. The respondent number 3 may be directed to take the decision upon affording opportunity of hearing to the parties
The
concerned.
district magistrate. District magistrate. should be
District
the-
magistrate, because the secretary has done this. Therefore, it has to be decided by the DM.
Chairman.
On prayer of the petitioner, the name of the 6th respondent be petitioners. The name of the 6th respondent be expunged from the cause title of the writ petition. Stop, the cause title be amended accordingly. Paragraph affidavit of service filed by the petitioners is taken on record. Paragraph, it appears that service upon the 5th respondent has returned with an endorsement, inverted comma, with the refused. Stop with refused, stop the which amounts to good service. Stop. The other respondents have been served. Paragraph. Third, learned counsels for the parties. The petitioners are aggrieved by the fact that a single bus bearing registration number WB 41J 9765 is plying in two separate routes under two permits issued by the authority. Stop. Learned counsel for the petitioner submits.
There is another vehicle that is WB 41J 2035. It also involves, there are two vehicles. These vehicles belongs to respondent number 5. Next vehicle. Page 18 and 19, page 18, second paragraph. Vehicle number is WB 41J 2035.
Yes.
This belongs to respondent number 5. And my allegation is, in this petition is against the respondent number 5. Therefore, this vehicle has to be mentioned.
It is this vehicle, not the other vehicle. This vehicle is running with two permits.
Yes, and another vehicle is,
WP
first vehicle belongs to respondent number 6. Second vehicle, WB 41J 2035 belongs to respondent number 5. Therefore, against this vehicle, my lord,
two permits are issued.
Two permit is covered at a time at the present moment. Therefore, the authority should be directed to take steps against this vehicle.
Vehicle number to KTB.
2035.
Registration number WB 41J 2035. The petitioner submitted an objection in this regard before the concerned authority. Will you file a comprehensive objection? Because this is before the secretary.
Yes.
So will you file an objection before
Yes,
the
yes,
DA?
Lord. Page 19, my lord. Receipt is there.
This is before the secretary.
Secretary, it has been deposited with the secretary. It has been submitted. But the difficulty is secretary has himself issued the permit against the
Yes,
certificate.
that's why I'm saying, will you issue a comprehensive representation before the DM? Will you submit?
My lord, the notice.
Because the representation
yes,
is not very
my
happy
lord, the
drafted.
notice has been issued. Notice that has been given page 21 before the authorities, before the DM. By notice. Yes, DM has been addressed to take the decision.
This is a demand of justice. Why don't you file a comprehensive an objection before the DM? Because page 19 objection is not very happily drafted.
My lord, may I pray this, my lord, this copy of the petition should be served upon the district magistrate for taking a decision in terms of your lordship's direction, so that my purpose would be served. But I can serve this copy before the district magistrate, and by which the DM may be directed to.
Instead of that, why don't you file a fresh objection before the DM? Maybe within 7 days.
Very well, I shall submit this specific objection before the DM within 3 days, and let the district magistrate be directed to take decide the same within.
You will file within 3 days.
Yes,
Or
by Friday.
7
By
days.
Friday, I shall submit. Within Friday.
The petitioner
Possibly,
seeks to-
I may be able to submit in course of tomorrow. I shall ask
Petitioner
my client
seeks to submit a comprehensive objection
before the DM.
in this regard before the district magistrate.
Respondent number 3, my lord. Respondent number 3.
Purva Bardhaman.
Yes,
Purva Bardhaman, comma, being the third respondent herein,
by Friday.
And-
Friday.
prays for a direction upon the authority to consider the objection at the earliest. Paragraph upon consideration of the submission made on behalf of the parties, comma, the petition is disposed of with liberty to the petitioner to submit a comprehensive objection before the third respondent within 3 days from
Yes,
date.
yes.
Stop. The third respondent is directed to consider and dispose of the objection within 2 weeks,
Yes, my lord.
within 2 weeks from the date of receipt thereof, upon according reasonable opportunity of hearing to all the stakeholders, including the petitioner and the private respondent, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of it. You can take this slide. You can take this slide. I'm not taking the instruction on record. It has no meaning at all.
One 125.
I am on petition. Now is the second round of litigation. The first round, my lord, the writ petition was dismissed, appeal was preferred by my client. My lord, there is a status quo order was passed by the honorable division bench. Another 2 appeals or 3 appeals have been filed. And all the appeals and my client's order, my lord, obtained with the division bench was violated, contempt matter pending. My lord, the division bench, during the pending of that contempt application, all the appeals considered and disposed of and dismissed. But while dismissing the matter, my lord, I pointed out the clause 9 of the notification issued by the district magistrate Purvabardhaman. I contended, my lord, that in view of the clause 9, permits issued by the regional trust of the Bardwan has been exempted from that notification. The honorable division bench, my lord, did not clarify, or please not to clarify.
Please let us come one by one. What is the initial order? Which
Well,
is
I'm
carried
coming,
in
madam.
effect?
I'm coming, madam. I'm coming. Now, the first year also kindly see the notification of the district magistrate Purvabardhaman. It is appearing at page 24 and P1. Page 24 P1, madam. The print type copy is there, madam. Page 24, madam. This is for restriction of the movement of the buses within the Bardwan town. Madam, may I bring to your lordship, if your lordship has an idea about town, madam, I don't know. Madam, the west side, Nababad bus stand, east side, Alisha bus stand. The administration, district administration decided not to allow the operation of buses in between the 2 bus stands within Bardwan town. Thereby, they restricted the operation of vehicle by issuing the instant notification of matter. Legality and validity of that notification is challenged, madam. If your lordship kindly come to page 25, first paragraph, if your lordship, what I contended before your lordship, madam. These buses, madam, the buses means madam, the stage carriages. Buses shall henceforth utilize the stands at Nababad and Alisha, depending on the route permits. Long route buses with permits issued by the State Transport Authority, West Bengal, regional transport authorities other than Bardwan, including SBSTC buses, shall also come under the purview of this notification. It is further notified that all long route buses of inter-district permits shall not enter into Bardwan town and move through bypass NH2. I contended, my lord, because there is exception other than Bardwan. We are the operators having permits issued by the regional transport Purvabardhaman. According to my submission, my lord, we are exempted from the purview of the notification. That was my submission, my lord. And if you will also kindly come, the order of the honorable division bench while dismissing the matter, my lord, if your lordship kindly come. That is appearing at page 41. And step P5. The longest order, my lord,
41, yes.
45, my lord, is 41, my lord, it starts, and your lordship kindly come on page 50. Paragraph 22. Has asked this court to indicate that the text of the notification in the paragraph 9 indicates that it does not apply to Bardwan town. That is wrongly recorded, madam. Mr. Chatterjee, appearing with the private respondent, submits that the notification does not indicate as such. This court does not venture to clarify the notification in question. The notification shall speak for itself. But that part is very important. In the context of that observation of the division by Mallet, page 51, and step E6. The petition before lordship made a joint representation before the district magistrate Purvardhan. And while doing so, my lord, the petition before lordship, my lord, made a statement that district magistrate Bardwan is the author of the notification. He is the best one. He can clarify the situation. My lord, that representation made page 6, my lord. But I submit, my lord, the basic principle, my lord, nobody can judge of his own cause. My lord, it's better, my lord, if your lordship can ask for a report from the district magistrate regarding the notification or my representation and come back, my lord, after 10 days or 2 weeks, my lord.
But if this is a notification is issued by the district magistrate, then who can clarify it?
My lord, your lordship has to clarify, my lord.
Well, yes, Mr.
Your
Bandapati.
lordship has to take a decision.
My lord, the repetition, my lord, thereafter, my lord, appeal. Appeal meant, my lord, to dismiss the appeal.
Not clarified. That person not clarified.
And thereafter, you have made representation before the authority.
I mean, say ground.
What was the observation of the division made? Mr. Samanto, page 50, madam.
Yes, yes.
Mr. Samanto has asked this court to indicate that the text of the notification in the paragraph 9 indicates that it does not apply to Bardwan town. Mr. Chatterjee, appearing for the private respondent, submits that the notification does not indicate as such. This court does not venture to clarify the notification in question. The notification shall speak for itself. There is no such and such. Interim order vacated, appeal dismissed. That way, no need to clarification, not any further.
What was the original order, the judgment?
In the appeal.
No, the original, the single bench order. Against which you prefer the appeal.
That has been indicated with the division bench order. If your lordship can come. Yes, I told you.
Single bench order.
Kindly come to page 43. Paragraph 5, my. It is only the state government that is empowered to issue any notification under chapter 5 and chapter 8 of the Motor Vehicles Act 1988. The district magistrate had no authority to issue any such permit. It is stated that the stage gas permits indicate that the bus stop at Bardwan town was at Tinconia. The import notification has the effect of altering a stage gas permit that has been granted to the petitioners. The district magistrate by the import notification sought to indirectly what he would not do directly. The import notification is therefore without the authority of law and hence illegal. The residents of Bardwan town would be seriously prejudiced if they would have to alight and board at Nawabad and Alisha bus stop. They would be compelled to additional local transport facilities at Bardwan town to reach their destination, and the most common destination being the railway station, etc. 6. The state government was represented in court below and filed a report. It was indicated to the single judge that also this court that the district magistrate has been empowered by the state government in terms of Rule 182 of Motor Vehicles Rules 1989
Such power to make and delegate the rules is conferred upon the state government by the Motor Vehicles Act 1988, inter alia both under chapter 5 and chapter 8. 7. In fact, it is the district magistrate in the facts of the case who is best placed to ascertain the ground, realities, and requirements and convenience of the people of Bardhaman. The construction of new bus terminal being necessitated is pursuant to changes in demography and population at Bardhaman town. It is essentially in public interest and for the larger benefit of the people of Bardhaman that the import notification was issued by the district magistrate. The single judge has heard the counsels for all the writ petitioners as in the court below. The writ petitioners appellants are represented by Mr. Khan, Mr. Samanta, Mr. Roy here. The single bench had addressed each and every one of the arguments raised by the parties, particularly the appellant, and they considered and decision of the Supreme Court, particularly in the case of Rajasthan State Fields and such and such. The court below came to the conclusion that the rules in question, that is chapter 5 of the Motor Vehicles Act, particularly Rule 72(2)(xxii), contain the power to attach conditions, permissions to safeguard permit issued and to be issued. The power under Section 6 of the Motor Vehicles Act to cancel the permit has also been discussed. The court below found that the powers under Section 115 and 116 of the Motor Vehicles Act stand on a different footing. That is chapter 8 and chapter 8 deals with control of traffic and empowers the state government to frame rules in this regard. It is essentially in this light that the state government had framed the West Bengal Motor Vehicle Rules 1989 and Rule 182 reads as follows. Rule 182 has been quoted. Page 48, paragraph 11. It is clear and evident from Rule 182 that the district magistrate, superintendent police, and commissioner of police by notification in the official gazette may regulate matters related to taking up and setting down passengers or both by public service vehicles, which undoubtedly includes the petitioners. The court below went on thereafter to analyze and rightly conclude that the district magistrate in the instant case was definitely authorized to issue the import notification by publication in the official gazette. This court has no reason to disagree with the findings of the learned single judge. But we have challenged the procedure regarding the issuance of notification. We have not challenged the authority of the. We did not challenge the authority.
So in the appellate order,
Appellate order in that cannot be
petition in its entirety has been affirmed.
Yes. Only portion is, my lord, what I indicated to except part 1 town. Except part 1. I indicated Mali.
Then you made that submission before the
did not clarify.
Not only that, yes, there is a clarification. The notification shall speak for itself.
Challenge before the Supreme Court. For that is the made a representation. We are not allowed to operate. For that reason,
notification doesn't allow you, you are not allowed.
We have made a representation. That has not been considered as yet. We pointed out your logic kindly see. Page 51. What do you have said?
Let the representation be considered without any observation made on this. Because prima facie, I feel there is no ground.
Otherwise, they will have to paper the approval before. My humble submission, your logic kindly decide. Let them take final
The
report.
division bench has decided already.
All the district magistrate cannot clarify.
Division bench has already decided.
Decided.
So this court cannot decide.
I am not on that. I know my limitation, my lord. I will not go beyond that. I say, my lord, I made a representation. When I have granted exemption in the review itself, except part 1 town, except part 1. Therefore, it will not come under the purview of the notification.
So let that be clarified by the district magistrate.
That has not been. Said this court does not venture to clarify the notification question. Then where shall I go?
The district magistrate will also say the notification speaks for itself.
Yes, my lord. For that reason, I made a representation with the district magistrate, and I said that paragraph T, the district magistrate Barwan is the author of the same notification. Therefore, she is the best person to know the intent of the legislature.
So let him consider your representation.
I submit, my lord, I submit, my lord, let him.
No, that is not possible.
No,
It has been noted already
Otherwise, my lord,
discussed, and all the points have been discussed.
what would happen? If
That is
the representative rejected, I have to come to your lordship again. My lord, kindly consider,
This court cannot help you out in this matter at all because the division bench has made an observation.
my lord, district magistrate can come to my aid.
The division bench has made an observation.
My
and
lord,
very
this is,
clear observation.
my lord, I cannot criticize the district order. District did not despite my prayer.
You have the appellate
No,
court.
ma, despite my prayer, it was not qualified. My lord, kindly consider this.
Single bench cannot deal with it.
My lord, I am not on that, my lord. I say, my lord, when the division bench put that question, my lord, undecided. This,
No, division bench has decided.
this,
Division bench has said the division bench will not clarify because the notification clarifies.
that,
That's it.
according to you, understand, entitled to operate. Because you have said, except part one.
Not at all. Not at all. Not at all. The division bench has very clearly said that the notification speaks
No,
for
I am
itself.
not, I am not criticizing, my lord. I say, my
No,
lord,
no question of criticizing.
My
You
lord,
cannot
the
do that before this bench.
notification itself says except part one. For that reason, I have come to your lordship. Where am I to go? Division on our prayer, it was not clarified.
If the
I made a
division bench-
representation with the DM. This is situation, kindly consider.
let the DM only consider your representation, nothing more. I cannot make any comment on this.
That if it is decided, if it is rejected, then
We cannot decide in
Your lordship,
advance.
I leave it to your lordship. I leave it to your lordship.
The division bench's order is
I
glaring.
leave it to your lordship. I leave, I
That is glaring at the
and the
face. I-
contempt matter is still pending with the division bench. And I have got a,
Yes.
before the appeal, before the starting of the appeal, before the division bench, I brought to the notice of the division bench, the contempt matter is pending. Madam, that was not taken care of. But I have subsequently, I have got a judgment of our court. Our court, convention of our court is when the contempt matter is pending, main matter shall not be heard.
Please do not make this submission.
No,
before
no, no.
this court.
This is academic discussion. What academic?
Petitioners assailed the notification issued on 6th June 2014 by the District Magistrate Burdwan, published in the Official Gazette on 31st October 2014 in 10 separate writ petitions. Stop.
Now, notification part, page 25, paragraph, first paragraph. Notification part.
Yes, it's recorded in the
Page 25, first paragraph. Which I rely. Other than part one.
You were the respondents in the appeal.
No. I have the appearance in the appeal. I also challenge them to petition.
The writ petitions were dismissed.
Writ petition dismissed, appeal was dismissed.
And the writ petitions being dismissed by a coordinate bench of this court by a common order dated 2nd September 2022, the petitioners carried the order in appeal being MAT 1534 of 2022 by an order passed on 26th July 2023, an honorable division bench of this court dismissed the appeals along with the connected applications. Stop. Correct. Paragraph 22 of the judgment in appeal records as hereunder. Page 50, 22. Correct. In view of such observation made by the Honorable Division Bench, comma, the petitioners submitted a representation before the District Magistrate, comma, Purbo Bardhaman on 4th August 2023 for a clarification as to whether the vehicles operated by the petitioners as to whether the notification as to whether paragraph 9 of the notification applies to Burdwan town, and also whether the vehicles applied by the petitioners are exempted from the said notification. Stop. The representation is yet to be considered. Stop. The petitioners pray for a direction upon the concerned authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of
Madam, may I
the
submit one thing, madam, make an observation that after my lord, the division bench judgment and appeal, which cannot be reviewed by the in a review.
Mr. Bandyopadhyay, as it is, the petitioners appear to have a very weak case. If I make that
The
observation,
notification cannot be reviewed, my lord,
Mr.
after
Pandey.
observation of the division bench.
the DM will go through the observation.
Well, make an observation, my lord, dear lordship, make an observation to that, my lord, effect, my lord.
I don't think that should be done, because in that case, there will be no consideration at all. If I make an observation,
Yes,
there
ma'am.
will be no consideration by the DM.
Yes, ma'am.
Let it be an open consideration. Place this order before the DM.
It cannot be reviewed after the observation and
That
it has
is-
been
that is the
decided
law.
by the division bench. my lord.
That is settled. But you will be given an opportunity of hearing, so place this order before the DM. Let the DM consider. I do not want to tie the hands of the DM.
Yes, ma'am.
Let him consider independently.
My lord, then, my lord, your lordship, my lord, without going into the merits of the matter.
I will, please. There is no merit. No merits to be gone into. Submitted on behalf of the state respondents that the second respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 1 month. 1 month,
Sometimes 2 weeks.
6 weeks. Within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Paragraph, it is made clear that this court has not gone into the merits of the case. And the third and the second respondent shall be at liberty to deal with the representation submitted by the petitioners independently in accordance with law.
May I play
Disposed
for
of which
this?
article?
May I play this in? Because
Limit of service.
the puja is coming, man. Your lordship, kindly make it 4 weeks, man. আমি বলছি পারবে no, there is no work in that, Mr. There is no work in that, Mr.
Again,
Kindly do it, my lord. I pay, this is fair, but before puja, my lord, I am paying. হবে না, আমি বলছি হবে না।
For puja, we are having 6 weeks. Puja is end of October.
End of October. We are, yeah, August, my lord.
This is August.
If your lordship want to.
By September it will be
My
done.
lord. Diplo.
Puja is end of 20th October.
That is started. এখন 2 সপ্তাহ আছে,
Yes.
2 মাস আছে। Puja does not depend from the date of the puja. Puja starts 6 weeks. আর 2 মাস আছে, এখন চলুন দিদি আপনার হয়ে যাবে। আচ্ছা।
Next.
মানে make it kindly my phone. এর মধ্যে তো বলেছে এর না না হবে না, কেউ করবে না। 6 weeks অপেক্ষা করুন। 6 weeks করে দাও না, বলছি আমি। দেখো না, আরে যদি না করে তো আমি
কাজ বলতে তার আগে কালকেও তো করে দিতে পারে। 6 সপ্তাহ 10 টাইম দিয়েছি, তার আগে তো হয়ে যেতে পারে।
Puja is long.
Let it remember.
Yes, next. আচ্ছা, আমি Yes.
this one.
126.
Yes.
আইনটা দি
লাইনটা দিতে বলো।
So Debra is there.
Yes, sir. I'm here.
Yes. Yes, Mr. Mukherjee.
This, I'm a permanent permit holder. The route, my lord, Bolaiponda to Kolkata.
Please speak into the microphone. Mr. Debra will not be able to hear you otherwise.
I'm a permanent permit holder. But this route is from Bolaiponda to Kolkata railway station. Now, my lord, this is an inter-regional route issued by the State Transport Authority, West Bengal. Well, this is, well, my permit was valid till 21st of January 2021. Now, I failed to make an applications within the period for renewal of the permit. There are 2 reasons I have stated here. One is this, the permit when expired, that is a period of Corona that was going on in January 2021. That's a period. One, and the vehicle which was operating at that point of time under that permit, that was seized and sold by the financer. I have stated, and the documents are also annexed here. That could not be possible to meet because the vehicle was seized by the Contai Cooperative Bank, which is under the hire purchase agreement with that bank, and they took over the position. And ultimately, we have tried my level best to bring the vehicle again, litigation going on, and that ultimately we failed, and the vehicle has been sold. I have annexed the document. Now, I made an application for renewal. There is a provision even after expiry of the period which has been given to the permit, the renewal can be made, and the applications may be considered, and the provisions in the rules also there, the acts also.
Vehicle?
I intend.
Where is the vehicle? Where is the vehicle, my lord?
The earlier vehicle has gone. I intend to that. That's my. I
intend to place the vehicle.
Yes. Let them consider. Let them consider. Let them say. Yes. Let them say.
Where are you?
Lordship, Lordship, not visible.
No. It's sufficient if you're audible.
Yes.
Yes, carry on, please. Yes, where is your new vehicle? Mr.
The
Mukherjee?
vehicle, this is a representation, not that the application for renewal, because let them consider it. If they say you have to place a vehicle, I have stated herein that I will place. So long I am not placing on the question of renewal or the permit cannot and does not arise, because without vehicle that cannot be. But let them consider my representation.
Representation is for renewal.
My lord.
Your representation is for renewal.
Renewal along with the money, your lordship will find in the representation I have stated. At present, it is introducing the
Third paragraph,
Page 21.
page, yes, my lord, page 21, my lord, representation, your lordship will find that I have stated in the lockdown period, then my lord, the paragraph, second paragraph, I have stated due to severe illness in corona period and lockdown, and the authority of state government regularized the flying of the vehicle was hampered, and my lord, in year the 2021, the vehicle of the permit holder was searched and seized by the instrument Contai Cooperative Bank Limited. I was given,
Kindly give me consent to procure a vehicle.
my lord,
The last line of your second paragraph. Why will the authority give you such consent?
my lord, your lordship kindly see the number and the state transport of the West Bengal, my lord, the last, that paragraph, last line, deposit the fee and the fine and
Kindly give me consent to procure a vehicle.
this is required, my lord. It is required. Let,
Purchase.
no, my lord, that I have instruction.
ছবিটা দেখা যাচ্ছে ওদের বলো একটু।
But the vehicle has already been, I have heard that the vehicle has already been procured, but it cannot be new one. But it cannot be registered unless they give the consent that you registered. It's a new one. I think so. It's a new one. It's a new vehicle, not the vehicle even. This vehicle is not an old one. The chassis, the chassis has been already purchased from the manufacturer. Number the erection of body and the temporary registrations is there, but the permanent registration, unless I get the consent that you place a new vehicle even. So only to that effect, let them consider, let them ask me to place a new vehicle even. I will agree, I already purchased because I have to place the vehicle. That's a new also, I am submitting on my learned friend is there, he told that this vehicle has been already purchased, vehicle without the body. Now the vehicle purchase a new vehicle.
Your representation doesn't say that you have a vehicle with you.
That is the difficulty.
Kindly see, these representation made sometime way back in March 2023.
Did you make a fresh representation?
Yeah, your lordship.
Because here
My
you need to place the vehicle.
Your lordship, allow me to face comprehensive representation, and there I will say the.
Let the petitioner make a fresh representation.
My lord. And also, my lord, he has to purchase the vehicle.
Yes, my lord, I will also, yes, I will say that in
And
a document to be annexed there.
Document to the annex.
Yes.
Otherwise, he cannot.
Yes.
Affidavit of service. The petitioner submits that he holds a permanent stage carriage for Bolai Panda to Kolkata railway station, issued on 25th January 2016, which was valid up to 21st January 2021. Stop. The vehicle bearing registration number WB33C 7786 covered by the permit was seized by the Contai Cooperative Bank. By the Contai Cooperative Bank due to violation of the terms of hire purchase, due to alleged violation of the terms of hire purchase by the petitioner. Stop. The being unable to release the vehicle from the custody of the financer / bank, the petitioner purchased a new vehicle and seeks to replace the same in place of the old one, ONE. Stop. The petitioner intends to submit a comprehensive representation before the concerned authority seeking renewal of his permit upon placing the new vehicle and all relevant documents pertaining to the vehicle and place for a direction upon the authority to consider the representation as a paragraph. It is submitted on behalf of the respondents that the secretary should consider.
Secretary is a replacement, my lord. Secretary should consider.
The fourth respondent be directed to consider the representation in accordance with law. Paragraph. In accordance with law, upon the petitioner placing the new vehicle along with all relevant documents before the authority. Paragraph. In view of the above, the petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the fourth respondent within
Within a week, my lord, within 3 days, I can, because this has been ready.
within 7 days from
Fine,
date. Stop. The fourth respondent is directed to consider and dispose of the representation within 6 weeks.
My lord, my lord, my lord, my lord.
From
Within
the-
6 weeks.
Can it be 4 weeks?
My lord, this is, if I place the, already I have. started, if I
4
pay-
weeks. Let it be 4 weeks.
From the date of receipt thereof, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner immediately. Disposed of.
Deeply obliged.
Shall I think the hearing matter also? Shall I think the fix for also?
Item 10, fixed at 3:30, item 10.
My lord, this was our writ petition, my lord. We had concluded our arguments, my lord, but it was quite some time back, my lord. Should I refresh, my lord, what had happened after that? My learned friend can start. Few minutes, my lord. Huh? Corona refresh.
But I have got a difficulty, my lord. Let him finish today, my lord. I have got a matter fixed at 4 o'clock.
He actually has finished. I think.
Yes.
We had finished, my lord. We had finished.
So let us start on the next day in that case. Because he again has to recapture
Right.
the next day. Yes.
My lord, in a short time, my lord, we want this
Next-
matter.
yes,
There's some urgency in this matter because, my lord, there's another writ
But next
petition.
next week, sometimes we are at 3:30. Like
My lord, can it be in some, my lord, at, my lord, at 2 o'clock, if it's possible, my lord?
I think it's 3:30.
Well, if it's some at 2 o'clock, or well, if it's possible to fix it 2 o'clock.
2 o'clock. We'll have to take up other matters also.
3:30 is apprehensive of divine intervention.
Divine intervention, no other. Well, then 3 o'clock, if I may request, my lord. If it can be 3 o'clock, my lord, instead.
Other matters suffer. I sit with a list of almost 300 matters a day.
My lord, this matter, your lordship has heard substantially, my lord. And my lord, there is some urgency on our part. Otherwise, I would not have made this request, my lord.
3:30 is safer, I think. On prayer of
Well, let them start, my lord. Then I have no problem. I was just thinking because it's been a while.
paragraph, let the matter
Yeah,
appear
Vishnu
at the
goes
same
next.
heading on. দিদি 29, 30 next week কোনো 3:30 রাখা আছে তাদের একটু দেখি বলুন।
Next week যদি করে দেয় কোনো অসুবিধা নেই। তারপর দেখিনি। অবশ্য বড় হলেও মন্দ হয়।
3:30 29th August,
Well, the interim order is till 31st August.
29th come back. 29th August, marked at 3:30 p.m.
Thursday.
Thursday হচ্ছে তো?
Thursday.
It's a Tuesday.
Tuesday next.
Oh, Tuesday.
One week. Tuesday.
I'm good.
Next one.
127. Hearing group 7, 127.
This is my application, my lord. Lordship will not take me amiss, but today, my lord, I'm opposing to any prayer for adjournment, my lord. This would be the 7th occasion. My learned friend is here.
Well, I am asking for some Passover.
Passover is not possible in this court, I'm sorry. Please make your submission.
I'm grateful, my lord.
Have you received copy of the affidavit in
Yes,
opposition?
yes. No, we already had. Your lordship's records did not reflect that the affidavit in opposition was there. We've made over a copy to them. It was incumbent upon them to bring it to your lordship. We are also carrying a copy. This is their copy. They've served it on us. Your lordship can refer to this one, my lord.
You have submitted the reply?
Yes, my lord. It's in your records. On the last occasion, your lordship was pleased to treat. No, affidavit in opposition to either.
Yes, the reply is on it.
Affidavit in opposition is perhaps not in the records of your lordship. my lord.
Original zero.
Yeah, I'm not. Ona there.
Opposition to record only.
Last order.
Huh? Let me just check.
Of course.
Only the railways as respondents.
Principal response.
State is also there?
No, the Union of India is the respondent number 1, but they don't really have anything to say. My principal respondent, answering respondent is the railways. my lord. In fact, the respondent number 1 is also through the Eastern Railway, my lord. General Manager, Eastern Railways.
No. Yes, there is the affidavit in opposition. I'll not rely on it in that case, if it is not on record. Yes, please make your submission.
Right.
You are appearing for the railways?
Yes, my lord.
You are appearing for the railways?
Yeah.
Yes? Please start.
Lordship, I have to call my senior.
Yes,
I
sir.
go and call my
You should have called by now.
May I, my lord? May I?
Conduct is absolutely deplorable. Yes, carry on.
My lord. Lordship, this matter pertains to consignments which were sent through the railways. I am the essential consignor, my lord. My goods, I am transferring from India to Bangladesh using the Indian railways, my lord, the Southeastern Railways. The allegations that have been levied against me is of undercharging. That is the quantum that I've demonstrated at the time of putting them, loading them in the train, my lord, were found to be undervalued. Therefore, there is a demand. Before I take your lordship, I'll just canvass out whatever's happening, my lord. So on the 5th of November 2006, my supplier, which is in then Andhra Pradesh, now Telangana, my lord, 5th of November, your lordship will mark the date, 5th of November 2006, the loading happens in the railways from this place called Karimnagar, which was then Andhra Pradesh. The total 5th of November 2006. That is when the loading happens at my behest from the location, my lord, where my supplier was supplying me the goods. The goods in question was several quintals of maize. The total quantum that I make over as a part of this transaction was 1,942.500 metric tons, my lord. 1940.500 metric tons of maize, my lord, in 32,900 bags in total. 5th of November 2006, it gets loaded in Karimnagar. 11th of November 2006, my lord, this gets unloaded at the destination station, which is in Bangladesh, which is essentially the exporter from Bangladesh. I'm sorry, the importer from Bangladesh, my lord, to who I am the exporter. So I sent the goods reach Bangladesh from November 11, 2006 to 14/4/2007, that is for a period of 6 months, they don't tell me anything. So I assume that this entire transaction has happened satisfactorily because my receiver has also got the goods. I've received the payment for it. I have paid the railways, whatever was owed. The transaction had come to an end. On 14th of April 2007, after conclusion of 6 months, they raise a demand against me. In that demand, they write that somewhere in the middle of the journey, in one of the stations during the journey, my lord, they re-evaluate the weight of the goods, wherein it is found that there is a certain quantum of the total number of bags which have been undervalued. So based on that, they raise a demand of a total amount of 11,65,219, 11 lakh odds, my lord, saying that you pay me the money because the goods that you have transferred is undervalued. Therefore, this is the amount of money that you're supposed to pay. I immediately reply, I say this total valuation itself is illegal because you could not have valued it. I must have been put on notice. Number one. Number two, this demand could not have been raised 6 months after the delivery had been completed. That was second, two contentions amongst other contentions, my lord. There is a separate transaction which also I'm using the railways for. My lord, there is a separate transaction which takes place on 9th of May 2007, post the demand, post my reply, where there were about 14 wagons of goods which were being transferred. They hold the entire goods in lien. They say that you pay me the money, otherwise I auction this off, I sell it. I reply, send a demand notice, demand for justice notice, assail that entire action before the writ court, my lord, in the year 2007. I obtain an interim order on the ground that this entire action prima facie, my lord, appears to be illegal. They could not have done this. So I am allowed to take back the goods. There's a bank guarantee, my lord. I'll be very honest. I'll be very candid to the court. The bank guarantee otherwise has stood expired. I will not conceal that. Stood expired, but because we are on hearing, my lord, I'm not going back on that. Two aspects. I take back the goods. I appropriate the goods. This is an admitted position of law, my lord. My contentions are threefold. Number one is, at the time of loading, the railways is required to issue a railway receipt, which is covered under Section 73 of the Railways Act. That railway receipt would be the quantification and the weighing of the total goods that I put in the railways, that is by way of loading. According to the Act itself, the railway receipt is considered to be the prima facie evidence of the weight of the goods. In my case, that railway receipt is issued. Also, the second bit of it, my lord, is that when I had received the goods from my supplier, which is in Karimgarh, during the time of loading, there are certain documents that have been made over to me, which quantifies the total weight of the goods. That is also on record. This now, before I take your lordship, trouble your lordship with the papers, this case that I put forth, my lord, is absolutely legal. It's a legal question. Factually, there is nothing, even in the affidavit in opposition, my lord, which your lordship may be pleased to take into account, may not be pleased to take into account. In the affidavit in opposition, they have not assailed or challenged any of the factual assertions. They've only said that they were entitled to in law. They are not, and then we weren't entitled to take back the goods. We were supposed to pay, and they were entitled in law to re-evaluate the weight of the goods during the journey. Which there is a judgment that I'll show to your lordship of the division bench passed by Justice Bhaskar Bhattacharjee, which says that otherwise it is impermissible. Lordship kindly takes up.
And you were not put on notice.
My lord,
You were not put on notice.
I was not put on notice. I was never put on notice until and unless the day I received the demand, which is 6 months later.
There is no provision as such, and at the same time, my lord.
Lordship kindly takes up page 29 of my writ application. 29, my lord, is an inspection report that has been issued to me. Upon this takes into account the date of loading and the date of unloading. This has been issued to me by a surveyor. Lordship, this starts from, my lord, page number 26. Lordship directly comes to page 29, which is a part of the report. Lordship looks at the top certificate of quantity. The heads, my lord, a consignment designated as, cargo described as. Lordship comes to the 8th head, my lord, page 29, sir. The 8th head, my lord, quantity.
Yes.
32,900 bags, which is equal to 1942.500 metric tons. So this is the disclosed quantum, my lord, that I disclosed. Lordship looks at 3 sentences right below that. We report as follows right after that, my lord. Place and date of inspection at railway wagon siding Karimnagar. Loading commenced at 11:30 hours on 5th of November 2006, which is the date of loading, and same was completed at 11 hours on 5th of November 2006. Sorry, this is the loading. This is the loading. The unloading is also there. Lordship kindly turns to page 31. This is where the railway receipt starts. The annexure to that is page number 32, which is the page right after that. Has your lordship seen page 32, my lord?
Yes.
This is slightly this is legible otherwise, but it was slightly difficult for me to show to your lordship. Lordship sees the columns on the bottom half of the page, my lord.
Yes,
Lordship sees this number 1110,
yes.
which is the fourth column from the left. So Lordship looks at the head on the top of it, heading on the top of it, actual weight.
Chargeable weight.
The actual
Oh, actual weight. and
actual
chargeable
weight.
Yes.
So this is in metric tons. There are two railway receipts. The first is 1110. Lordship turns to page 34, one page after that, my lord. Exactly same place. 832.5.
34.
Page number 34.
Yes,
This is the second part of the railway receipt.
yes,
832.5.
yes.
So if your lordship calculates the two, aggregates it, the total comes to 1942.500 metric tons, which is the total weight that I have disclosed at the time of loading. Lordship looks at the date of these two bits of the railway receipt, my lord, which is top half of the page. On the right, your lordship would see the receipt number. Right on the left, my lord, 5th of November 2006.
Yes.
So this is issued on the date of the loading. And this is the railway receipt.
These are two separate consignments? Or the
No,
same?
this is a part of the same consignment based on the number of bags. So as a part of the same consignment, they've issued.
Two payments.
There were two?
Two separate payments. Like the
No, they are
Oh,
just
wait.
two separate receipts, my lord, which have been issued.
no receipts, the parcels were also weighed separately.
Possibly
This
no.
comprises a few bags, the other comprises the remaining.
Possibly, because this went in a total of 34 compartments
Oh.
of the railways. So they have
couldn't
possibly,
been weighed at a time.
yes, could not have been, but my goods which were being loaded or were all weighed, because these 32 wagons belong to me in terms of the fact that they were booked under my name. And these two railway receipts have probably been split, my lord, because some of the wagons have been taken as a part of one a set of compartments, and another railway receipt for a different set of compartments. Lordship kindly turns to, my learned friend is correct. Lordship kindly turns to page 36 of my writ application. This is the invoice cum packing list, my lord. This is the customs clearance, which I'm required because I'm sending this to Bangladesh.
Yes, 36.
Lordship comes to the middle of the page, which starts with, we certify that the goods is of Indian origin.
Yes.
There is a certification. Lordship looks on the right, quantity metric tons 1942.500. The rate is given, the total amount in US dollars is given.
Yes.
Lordship looks at the stamp on the right of the page, my lord. That your lordship would find a stamp. November 2006, this would be on receipt. Inspector of Customs, Ranaghat, RS, LCS. So this, at the time of receipt also, my lord, at the time of unloading, also the custom clears the total amount of, the total quantum of the goods, the total weight of the goods. This the customs, your lordship, would understand that is required to do it upon weighing the same, without which they cannot assert or confirm this information. Lordship then kindly turns to, I'm not troubling your lordship with the rest of the documents, I'm directly troubling your lordship to turn to the demand notice, my lord. Lordship will kindly give me one moment, my lord. Lordship kindly turns to page 40.
Yes.
Lordship looks at this. This is a handwritten document where they assert the total overweight, the quantum of the weight, which is over what has been disclosed. Lordship,
This is the demand.
this is a part of the demand. This is where they assert the total overvaluation. I don't know the validity of this document, my lord, because this is neither signed. No, it's signed on the next page. There's a handwritten document. I don't know the veracity of this. I'm sure my learned friend will say that this is possibly the format that they follow. I wouldn't have any idea, my lord, to that. Lordship turns over to the next page, page number 41. Lordship looks at the right-hand column at the bottom. They calculate 31 wagons, my lord, on the basis of which they assert that the total amount equivalent to the overvaluation is to the tune of 11,65,219 rupees. This is a part of their demand. They say that this has been issued on the basis of a calculation of the weight, which has taken place on 9th of November. Your Lordship has already marked that the loading was on 5th of November. The unloading was on 11th of November. So 9th of November was the journey. This was in one of the stations, my lord. Page number 42 is where they assert this. Page 42 of my REIT application, Lordship looks at the date, middle top of the page, 9/11/2006. This is the middle of the journey. The directions are also given. So this would possibly be the directions of the train that it's taking. Lordship looks at the chart. There are 36 BXC wagons, whereas the total number of wagons that were issued to me, and I've pleaded that in my writ application, which were under my name, which were carrying my goods, were a total of 35 wagons. In this, they weigh a total of 36. I do not know how they reach that figure, even though the quantums which are assignable to the last wagon, my lord, is 0 in all of them. So I don't know how that's helping their case. They reach the conclusion that the overvaluation is for a total quantum. I'm sorry, my lord, the undervaluation is for a total quantum of 1854 quintals. Lord, you will kindly mark that figure, my lord.
Yes.
1854 quintals, which is equivalent to 185.4 metric tons, because my calculations and the original receipt, my lord, the railway receipt was issued in terms of quintals, metric tons, my lord. I have converted that.
Where
So-
do you find this 1854 quintals?
Just one moment.
At page 42.
Just one moment. Lordship comes to page number 40. This is where it is, madam. 40, Lordship looks at the portion right after dear sir. This is to inform you that undercharge has
185.
been raised against you due to overweight of 1854 quintals. This is the quantum that they are saying is in excess of what I have disclosed, in excess of what has been valued at the time of unloading, and what features in their railway receipt. For your lordship's convenience, I've converted this amount, my lord. This comes to 185.4 metric tons. So if my total quantum was 1942.500, they are saying that the total weight that traveled with them was 1942 plus 185 metric tons. So I respond to this by my representation dated 18th of April 2007, which is in page 43, my lord. May I just read it for your lordship's convenience, one? In this connection, this is the second paragraph, my lord. In this connection, we would like to inform you that we have loaded 1942.50 metric tons, which can be ascertained from the weightman certificate received from reputed independent international surveyor so-and-so, and also from the bill of our supplier. We have paid total freight for 1942.50 metric tons and loaded 1942.50 metric tons only. Lordship disregards the portion in the paragraph, within the brackets. We are mainly engaged in export traffic and all our orders are covered with letter of credit. We have to load nearly the LC weight in order to get payment from the bank. If we will do over or underloading, we would land in huge problems with concerned government authorities. Moreover, for BCXC wagons, the maximum capacity is 55.5 metric tons per wagon. Thus, the total maximum capacity of 35 BCXC wagons is nearly 1942.5 metric tons, which is the quantum that I was relying upon. The rest of it, my lord, is not relevant. In the next page only, my lord, I deny paying this amount of money. Pursuant to which, your lordship, they take steps to attach the next consignment that I sent through the railways. They put it up on auction. I'm not troubling your lordship with the rest of the documents, my lord, because that already, as it is, my lord, has become infructuous. I'm directly coming to the judgment. I'm only relying upon one judgment, my lord. I'll keep this very short. Huh? Before that, my lord, my learned friend is correct. Before that, may I just take your lordship through 3 provisions of the Railways Act, my lord? I'm carrying the bare act. I'm the sir, my doctor.
Yes.
Lordship kindly takes up section 65 of the Act, my lord. 65, sir.
Yes.
Receipt, my lord. A railway which is a railway receipt. 1. A railway administration shall A, in a case where the goods are to be loaded by a person entrusting such goods on the completion of such loading, or in any other case on the acceptance of the goods by it, authorized in this behalf, and a statement to that effect is recorded in such railway receipt by him, the burden of proving the weight, or as the case may be, the number of packages stated therein, shall lie on the consignor, or the endorsee. The proviso does not get attracted because they disclose it in the railway receipt which I've placed before your lordship. So the question of the weighing not happening pursuant to section 65, my lord, by an authorized railway servant does not arise. So this has been weighed. Admittedly, this has been weighed. They've disclosed it in the railway receipt. So, and I also understand the limitation that I have, my lord, because this railway receipt would only act as a prima facie proof of evidence. My lordship kindly turns to section 73, my lord, which deals with punitive charges. I'll disclose this would possibly be my worst section that I can show before your lordship. Maximum, 73, my lord, punitive charges for overloading a wagon. Where a person loads goods in a wagon beyond its permissible carrying capacity as exhibited under subsection 2 or subsection 3, or notified under subsection 4 of section 72, a railway administration may, in addition to the freight and other charges, recover from the consignor, the consignee, or the endorsee, as the case may be, charges by way of penalty at such rates as may be prescribed before the delivery of goods, provided that it shall be lawful for the railway administration to unload the goods loaded beyond the capacity of the wagon, and this is very important, my lord, if detected at the forwarding station or at any place before the destination station, and to recover the cost of such unloading and any charge for the detention of any wagon on this account. So today the railway, if there is a undervaluation which has taken place, the railways, number 1, has the right power under the statute to impose punitive action against me in the form of money, of course. They also have the power to dispose it off. So the moment the statutes, my lord, says, and this I'm trying to draw an inference, this is subject to what your lordship feels, that the moment the statute, my lord, says that the railways has the authority to throw the goods out and then put me at risk in cost, this would invariably mean that the railways would have to either inform me that there is an overweighing, that there is an undercharging, or that I should be given an opportunity to pay that amount of money so that the railways decides to keep on carrying the goods till the destination station. So in this situation, the fact that the weighing of the goods happens on 9th of November 2006, they cannot inform me 6 months later. Number 1. First bit of it. Second is they can't complete the entire transaction by reaching the destination station, unloading the goods, giving it out to the consignee, and then they say that this has been undercharged. I'll take your lordship directly through the judgment, my lord. There have also been, because the judgment itself, my lord, takes into account certain provisions of the Act as well as the regulations, my lord. So I'll not trouble your lordship separately for that. Lordship kindly takes up the judgment, my lord.
It's an unreported judgment.
This is an unreported judgment. I'll make over a copy, my lord. Missing a copy. In fact, my lord, this is not available on the server. I've checked. This has not been overturned. This is still in vogue division bench, but this appears to not be available. So the copy
2007 judgment difficult to be.
2007,
served.
my lord. That is the only difficulty. In fact, based on this judgment, my lord, I believe that the instruction to file my writ application was given. I wouldn't recollect. I was in class 7 back then, but this would possibly be the logic, my lord. Lordship kindly turns to page number 4 of the judgment, my lord. I'll just indicate one small portion of the facts. Lordship looks at the third sentence. The case made out by the writ petitioner may be summed up. In this case, I'll just give a little background, my lord. Similar, page number 4 of the judgment, my lord.
Yes.
In this case, I'll give a little background, my lord. The writ application was filed by a similarly stated person. The single judge, my lord, decides that these orders attaching and for sale of the goods and the lien, it must go because of non-compliance. The respondent authorities, my lord, assail that order in the appeal which is before Justice Bhattacharya. Lordship kindly takes up A. On October 8, 1991, Messrs. Hari Trading Company and Messrs. Lakshmi Trading Company dispatched iodized salt consignments from Chirai, Gujarat to Behrampur, West Bengal in 30 wagons against bills for rupees 3,20,000 odd, my lord, and 2,42,000 odd, respectively. The railway authority at Chirai issued receipts against the loading of such consignments containing endorsements as follows. Senders wait accepted SM en route to wait and advised jointly destination to wait before delivery. The senders engaged JB Boda Surveyors Private Limited for supervision of crushed salt in bags for human consumption in BG wagons and for weightment of the bags at random. B, my lord, 24 wagons out of the aforesaid 30 wagons reached the destination station in Behrampur court, where when shortage of 1141 bags of salt were detected and short certificates were issued to that effect. The writ petitioners were informed by the station superintendent, Behrampur Court, Eastern Railway, as per his communication issued under memo dated so and so, my lord, for an amount of rupees 52,938 was chargeable as weightment charge as per weightment order dated October 12, 1991 and October 14, 1991 against the aforesaid weightment. The writ petitioners were consequently asked to pay the aforesaid amounts to clear the outstanding dues as well as to enable the office to deliver the balance consignment of salt. My lord, the rest of it is facts. It's not relevant. I'll take your lordship to the ordering court. It has reported, but আমার citation pen. আমি আপনাকে এই কপিটাই দিই, আমার কপিটাই দিয়ে দেবো স্যার। আমি relevant portionটা আপনাকে বলে দিচ্ছি। আমি দিয়ে দেবো স্যার। Okay. Lordship kindly takes up the ordering portion, page number 9 of the judgment. My lord.
Yes.
Lordship looks at the second paragraph. Therefore, the question that falls for determination in this appeal is whether the learned single judge was justified in allowing the writ application by passing the direction impugned in this appeal. In order to appreciate the points involved in this mandamus appeal, it will be profitable to refer to the following provisions of the Railways Act. My lord, there are a couple of provisions cited. I will be troubling your lordship with these, my lord, because they might be of some relevance. I'm not showing the bare act separately. Railway receipt, my lord, I've already shown 65. Lordship turns over to the next page. 72, my lord, maximum carrying capacity. This is not very relevant. Lordship kindly turns over. 73 also, my lord, have shown. Lordship kindly turns over to 12. Page number 12. Lordship looks at section 74 of the Railways Act. Passing of property in the goods covered by railway receipt. The property in the consignment covered by a railway receipt shall pass to the consignee or the endorsee, as the case may be, on the delivery of such railway receipt to him, and he shall have the rights and liabilities of the consignor. Next, 78, power to measure and weigh. This is very important, my lord. Notwithstanding anything contained in the railway receipt, the railway administration may, before the delivery of the consignment, have the right to, and this is possibly what my learned friend is going to rely upon, remeasure, Roman 1, remeasure, reweigh, or reclassify any consignment, recalculate the freight and other charges, and correct any other error or collect any amount that may have been omitted to be charged. So if your lordship harmoniously reads the 3 serial numbers, my lord, under section 78, lordship would look at Roman 3, which says that correct any other error or collect any amounts. If there is a question of a collection, this would essentially have to be done before the destination station is reached. But I'm not getting into that. This would be his case to place. Section 79, waitment of consignment on request of the consignee or endorsee. A railway administration may, on the request made by the consignee or endorsee, allow waitment of the consignment subject to such conditions and on payment of such charges as may be prescribed and the demurrage charges, if any, provided that except in cases where the railway servant authorized in this behalf considers it necessary so to do, no waitment shall be allowed. I'm not reading the rest, my lord. This is with respect to where the consignor himself has asked for reweighing. In this case, this provision does not apply. Lordship, this would be practically it, my lord, for the act. Lordship, there are certain regulations which have been referred to. I will, in fact, my lord, for your lordship's reference, make over a copy of the regulation, my lord, also. I have not taken the trouble, my lord, lordship will forgive me, of putting in all the regulations. Only the regulations which have been cited in the judgment, my lord, have been covered in the docket that I've made over, my lord. Regulation 1422. Your lordship, for the time being, may refer to just the judgment itself. It takes into account everything. Regulation 1422. Weightment of outward goods. A. Outward goods should be weighed as indicated below. The particulars of weightment being entered on the forwarding note in the place provided for the purpose. Roman 1. Consignment in small lots. All consignment should be weighed in full at the forwarding station. Roman 2. In bolds, my lord. Consignment in wagon loads. In the case of consignments of grain, salt, seeds, sugar, pressed cotton or other staples in bags or bales of uniform size and weight, the weight declared by the consignor may be checked by weighing a proportion of the number of bags or bales of uniform size and averaging their weight. If the bags or bales are not of uniform size and weight, those of uniform size and weight should be grouped separately, each lot being treated for the purpose of weightment as a separate consignment and weighed as such. The remainder of the consignment of bags or bales or other commodities not of uniform size should be weighed in full. The proportion weighed should not be less than 10% at situations where the traffic is large and 20% at other stations. Sub-regulation 2 is not relevant, my lord. Lordship looks at 1424. Page 14 at the bottom half of the page, my lord, 1424.
Yes.
At weight bridge stations where the wagons are required to be weighed, the station master should ensure that such weightment is done and that the wagons are not pushed on without weightment. The result of weightment should be recorded in the weightment register in form so-and-so number, my lord, which should be written in duplicate by carbon process separately for local and through traffic. The pencil copy of the register should be retained as station record and the carbon copy submitted monthly to the traffic account officer along with the returns. The result of weightment should also be recorded by the weighbridge station staff on the wagon labels and invoices. The latter should, after being stamped with the nature of the weighbridge station, be sent forward to the destination for accountal and recovery of charges. So, lordship, this would need some consideration from your lordship. If your lordship looks at the last bit of the regulation, my lord, the last sentence, the latter should, after being stamped with the name of the weighbridge station, be sent forward to the destination for accountal and recovery of the charges. So that has not taken place. This is actually squarely applicable in my case, because this is essentially what they would fall back on by saying that even before the destination station is reached at any other forwarding station, I would be permitted to re-evaluate the weight and then find out if there is any undercharges. And they have done this, they've fallen back on this. But the compliances which are required to be done under that, my lord, in regulation 1424, they failed to do. That would be my case. Next page, my lord, 15425. In addition, a separate telegraphic advice of the net weight found on weightment should be sent together with the booking particulars to the forwarding and destination station and to the traffic accounts officer of the destination station. The destination station should in all cases paste the telegraphic weightment advice on the relevant page of the delivery book. The result of weightment as also the particulars of the weightment advice being recorded against the connected entry in the delivery book. Not done. Pachu looks at regulation 1426. Stations unable to weigh consignments due to weightage machine problem. This is not their case. Therefore, I'm not troubling your lordship with this at all. 1431. unless they take this as a, in their reply, saying that this would be, this has not been disclosed in the affidavit in opposition, therefore I'm not relying upon it. 1431, testing of weight bridge by weight bridge inspector. All weight bridges will be tested half yearly. This is also not relevant, I'm really sorry about it. 1442, preparation of invoices. After the goods have been carefully checked, counted, weighed and examined as to the compliance of the packing condition, etc., and freight and other charges have been calculated and entered in the forwarding note, invoices should be prepared. In this case also it hasn't, it has come by way of a demand notice, that to 6 months later. They don't disclose that at the destination station itself, the invoices would have to be raised after the forwarding station sends it. They don't disclose that. 6 months later, they send me a demand notice, and they don't take into account my response either, which would also be a on the ground of Article 14 violation. But I'll take that at the end. Lordship kindly turns over to the next page to the proviso. This seems to have been emboldened by his lordship. Therefore, I'll take your lordship through this portion. Provided that in the case of a consignment in wagon load or train load and the weight or number of the packages is not checked by a railway servant authorized in this behalf, this is in a sense, my lord, a reproduction of the statute which I've already shown to you.
My lord, other matter.
Yes. Provided in the case of a consignment in wagon load or train load and the weight or number of the packages is not checked by a railway servant authorized in this behalf, and a statement to that effect is recorded in such railway receipt by him, the burden of proving the weight, or as the case may be, the number of packages stated therein shall be on the consignment. In my case, they cannot put this burden on me because their case, my lord, as on date does not stand to say that the original valuation of the weight had not taken place. Lordship kindly turns over, not turn over, my lord. Lordship kindly looks at 1451 also. I'll trouble, my lord. Grant of receipt full of invoice to the consigners. As soon as an invoice is prepared and the weight and the freight and other charges, if any due, have been collected, the receipt foil and the invoice should be given to the sender, who will forward it to the consigner at the destination station. Not done. B, my lord, railway receipt, that is receipt foil of invoices, which is 65 of the Act, should not be granted till goods tendered or dispatched have been correctly examined and weighed. When senders are required to load their consignment, the railway receipt should not be given until the loading has been completed to the satisfaction of the railways. This would possibly be my strongest case, my lord. That once that has been granted, the reason it's considered to be prima facie proof of evidence, my lord, is because once it is granted, it will be presumed that the railways has taken absolute abundant caution in reaching the figure and ascertaining the same. Lordship looks at C also, my lord. There should be no undue delay in the issuance of the railway receipts to the consigners. There must be made over to them on the very day the consignments are accepted for booking, or in the case of consignments required to be loaded by the consigners on the day of the consignments are loaded. Not very relevant, my lord. This has already been issued in my favor. Lordship turns over, my lord. Responsibility of stations for undercharges. Receiving stations are held responsible for recovery of undercharges on the goods traffic, both local and through, whether paid or to pay, except in the following cases, which are debitable to the forwarding stations. In all cases where repayment of freight is compulsory, undercharges and or of and under 1 rupee in freight paid by credit note and percentage charges due to animals, birds and goods not covered by the case, my lord. I'll not trouble your lordship with it. Lordship kindly turns over.
You'll take some time.
I'll take about 10 minutes, my lord.
Well, only my suggestion would be, let us file our written notes of argument, because I have to say something. They are saying something.
I would like to hear the matter. I do not want written notes of argument.
No written notes of argument.
I'll hear the matter.
Then would it be a lordship's pleasure to give me 10 more minutes? I'll conclude my
Not
submission.
today. There's a meeting actually.
Very well. Definitely. Definitely.
And your affidavit in opposition is not on record.
It is here. Is it
It
not
has
on?
not been submitted. So the court cannot take cognizance. of
If your lordship so desire, I can reconstruct that because it is with me.
that was the direction on the earlier date. That has not been done.
Reconstruction করনি reply এটা এই opposition টা
This was submitted on the earlier date. There was a direction for reconstruction. You wanted to submit a fresh copy that you have not given that.
That is your lordship kindly pardon me. Only thing is your lordship kindly give me some time so that I can assure your lordship that we'll file it.
It's not a very complicated or a very big issue. We can complete
Yes,
it on the
yes.
next date.
I can assure your lordship only this, my lord, that the ratio of the judgment would be the final sentence I'll say in, which is the next 10 minutes. I'll conclude. There is nothing else in the case. This is it. I don't want to trouble your lordship. No, not today, my lord. Any other day. Lordship keeps it. If I may say so, my lord, lordship kindly keeps it anytime this week or next week, my lord.
Only thing is your lordship kindly grant me leave so that we can file that. That has not been done.
That was granted already.
Now that we have not submitted. তোমরা দাওনি তো।
Heard learned counsel for the petitioner. Paragraph, let the matter appear under the same heading for further consideration on.
Give me some more time, my lord, because I will have to ask them to come and explain me about this, the act of.
They've had a significant portion of time, my lord.
Yes.
They've had time since September 2022 to get instructions.
Several
unless I get-
adjournments, several accommodations, conduct is really deplorable of railways.
Earlier there was another lawyer. After that, it has come to me.
I am
So
not, this court is not concerned.
not
I'm
concerned.
concerned
I agree. But the only thing is, your lordship can. give
will
me
you
some-
come back on 5th September? On 5th September.
5th September. that should Tuesday. Would it, I don't have a difficulty coming back on that date. Would it be your lordship's pleasure to kindly fix it at 3 or 2?
Yes, I will not 3, Didi. এটা উপরের দিকে রাখুন তো 5th September. Group 7 hearing এর উপরের দিকে রাখুন।
It is already a top on the list.
I don't know, my lord. if this will-
Only thing is, in the meantime,
My lord, if this,
Heard, so I want to dispose of.
would it,
it.
lordship,
in the
would it be your
meantime, my
lordship's
lord,
pleasure
your
to kindly
lordship
make it
grant
part
me
heard?
leave
Not
to file that.
necessary.
Lordship kindly makes it part heard.
Part heard, I
because-
cannot make matters part heard.
Only thing is,
On the point, my lord, if there is,
Part heard matters.
lordship understands if there is any intervening, anything that
think so.
happens, my lord.
It's just a few days.
only thing is, my lord, your lordship kindly grant me leave to file this. This is the opposition afresh. Kindly
I'm
allow
opposing
us.
to that, my lord.
How can it be afresh? You have to reconstruct the one that you've given to the, you've given the petitioners already.
Yes, but it is not,
No,
it is
it
not
is not
here
on
in the
record.
file. That is the difficulty. But
Come back with a copy, I'll accept it.
okay,
Lordship, I was just taking a look at the one that was served on me, my lord. Substantially on facts, they've not dispelled
that will
anything.
be decided
Very well.
Oh, take it in.
on 5th.
5th. And it
Lordship
will
has been-
probably be the first matter. Please be ready. The first hearing matter.
But only thing is, madam, my junior is asking for a more week, 1 week.
No. Sufficient time. 5th, the first hearing matter.
I'm deeply obliged.